You may be seated. That works pretty good. Good morning. This hearing will come to order before the commission today as docket number 25003U, which is styled in the matter of the application of Southwestern Electric Power Company for approval of a general change in rates and tariffs. This hearing was scheduled by order number 4, issued in this docket on May 15th, 2025. In order number 16, issued on November the 14th, 2025, the Commission made additional rulings regarding the procedures for today's hearing, including this hearing will be conducted for the primary purpose of considering the merits of the proposed settlement. The order of parties will be SWEPCO, Sierra Club, and Audubon, U of A, and AAEA, City of Fayetteville, Walmart, Waylick, the AG, and staff. All pre-filed testimony and exhibits are admitted into the record. All witnesses, other than those identified in order number 16, have been excused from attendance at this hearing. And finally, the Commission acknowledges that the settling parties have agreed between them to waive cross-examination of all witnesses, including witnesses filing settlement testimony consistent with their joint motion in the November 10th, 2025 letter concerning the non-settling parties, Audubon and Sierra Club. Am I correct in stating that all parties have waived cross-examination? Ms. Tacker?
Yes, Your Honor.
Mr. Pennington?
Yes, Your Honor.
I can't see everyone's name, but are you in agreement, sir?
Yes, Mr. Schrader.
Thank you. Mr. Bynum?
Yes, we are. Yes.
Yes.
Thank you. And staff?
Yes.
Yes, thank you. Please silence all cell phones and other electronic devices, including your computers. For those in the hearing room, if you must take or receive a telephone call during the hearing, we ask that you please step into the hallway to do so. Also, for those in the hearing room, you may access the Commission public Wi-Fi system during the hearing simply by connecting to the internet. Because the pre-filed testimonies and exhibits are considered part of the record, and the court reporter will not be inserting pre-filed testimony and exhibits into the transcript, the attorney should authenticate the testimony and exhibits filed by their witnesses by stating the name of the testimony and the exhibit and the date it was filed when your first witness is called. The parties have stated that they waive cross-examination. Please note that the Commission's long-standing hearing rule will be in effect during the hearing, meaning that once cross-examination of a witness has been completed, and since we don't have any, once the witness has been presented, the witness will be tendered for questioning by the Commission. Further redirect or cross-examination of the witness by the counsel will not be permitted. That goes without saying. Further, the parties are reminded that this case includes protected information, including highly sensitive protected information. Members of the public are advised that the hearing room may need from time to time to be cleared with the exception of the persons who have signed the proper affidavits of non-disclosure. Parties are advised to inform the Commission if and when a party intends to reference confidential information, in which case the Commission can determine whether to go in camera. And it's conceivable the Commission might delve into an area that's confidential and we might need to be reminded to go in Cameron as well. Are there any other procedural matters?
Yes, Your Honor, may I approach?
You may.
I'd like to note 3 corrections to the settlement agreement.
Okay.
The first correction was filed yesterday as an errata. It is a revised HSPI Attachment 1. The last column of that attachment was inadvertently removed. Later yesterday afternoon.
And so the filing corrected the removal and included that.
Yes, sir.
Okay,
It is
thank
now corrected on the record.
None of the numbers changed, it was just the addition of that column?
Yes, sir. None of the numbers changed.
Thank you.
In the latest filing in this docket yesterday afternoon, the parties recognized that there was an error in the numbers in attachment 2. And that error was corrected with an errata filing. That is not HSPI. And it changed lines 36, 38, and 41. The totals in that spreadsheet are not impacted by that errata, but it is now filed in the record and is correct. One other item I'd like to note that was discovered very late last night. In paragraph 27 of the settlement agreement on page 7, there is a clause in parentheses indicating that the city of Fayetteville does not take a position on the provision that is in paragraph 27. That position, the parens, should have been included in paragraph 28 rather than paragraph 27. Because it was discovered very late last night, we have not had an opportunity to file an errata, but would like the commission to be able to acknowledge that correction here at the hearing.
May I, Chairman?
Go ahead, Mr. Tate.
So just to clarify, Fayetteville is an agreement on the CCR for Welsh, but takes no position on Flint Creek.
Your Honor, that's my understanding, but perhaps you'd like to speak with counsel for the city of Fayetteville to clarify that.
Mr. Pennington, would you like to clarify?
That is correct.
Thank you.
That's all I have, Your Honor.
Okay. Those have been filed in the record, and they're certainly admitted into the record as well. Thank you for the corrections. Any other procedural matters? For the record, will the attorneys state their appearances and the names of those persons they intend to call as witnesses? Ms. Tacker?
Yes, Your Honor, good morning. I'm going to step to the podium.
That's right. And we appreciate people stepping to the podium. It picks it up on our, for purposes of the public. Thank you.
Good morning. My name is Sarah Tacker. I'm appearing on behalf of SWEPCO. Along with myself, SWEPCO is represented by Ethel Drita Smith. She goes by Drita, just in case that clarification is useful. We will be presenting 5.
Ms. Tacker, I don't think your mic was on initially, but it went off. Let's get that fixed quickly before we.
Testing.
Yeah, it's not coming
We're
through.
checking.
Yeah, just a second.
Yep. Thank you. We actually have more trouble with that mic than we do the attorneys. A lithium Bible, a battery Bible. There you go.
Sorry to interrupt you. I just wanted to make sure that they can hear you online. Thank you.
Yes,
You may-
ma'am.
Why don't you
Thank
start again? Uh-oh.
Well, isn't that a fun introduction?
That's a different problem, but maybe it's.
Good morning. My name is Sarah Tacker. I am appearing on behalf of Southwestern Electric Power Company, or SWEPCO. I am accompanied by co-counsel Drita Smith. We will be presenting 5 witnesses today in the following order: Melissa A. Gage, Lynn Ferry Nelson, James F. Martin, Jeffrey Ellis, and Jason Stiegel.
Okay. Mr. Bynum?
Good morning. It's Randy Bynum. I'm appearing on behalf of the University of Arkansas System and also the Arkansas Advanced Energy Association. We will be having one witness today, Dr. Larry Blank. Thank you.
Thank you. Mr. Pennington?
Good morning. Blake Pennington on behalf of the city of Fayetteville. We have one witness today, and that is Peter Nierengarten.
Thank you. WALEC, Mr. Schrader?
Good morning, Commissioners. Tom Schrader appearing on behalf of Western Arkansas Large Energy Consumers, otherwise known as WALEC.
Thank you.
And WALEC will have one witness appearing today, Mark E. Garrett. Thank you.
Thank you. Ms. Chandler?
Good morning. Dorley Chandler on behalf of the Attorney General's office. I have with me Michael Lewis and Michael Coots from the office. We will be presenting one witness, Greg Myers.
Yeah, okay. They don't have a witness. Okay. Walmart? How could I forget Walmart?
Rick Chamberlain appearing for Walmart Inc. Is that on?
Thank you.
Walmart did file testimony of Miss Lisa Perry in the case, but she has been excused from the hearing.
Thank you, sir. While I'm catching back, Audubon and Sierra Club, Mr. Nolan.
Ross Noland on behalf of Audubon. Neither of our witnesses are present today. Thank you.
Thank you, sir. Ms. Kelleher.
Thank you, Mr. Chairman. I jumped the gun there a little. My name is Dawn Kelleher, and I represent General Staff. I have with me co-counsel Miles Parks, and also sitting at council table is David Scott, our Chief of Legal Division. We will be presenting witnesses Middleton Ray, Victoria Temple, Mark Burdett, Christopher Spadoni, Michael Marchand, and Regina Butler, pursuant to order number 16.
Thank you, Ms. Kelleher. Will all the witnesses that intend to testify please stand and raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? Thank you. Be seated. Finally, opening statements shall be limited to a maximum of 10 minutes for each party. Before we move to opening statements, are there any other motions or procedural matters that we need to address? Seeing none, Ms. Tacker, you may proceed with your opening statement.
Thank you, Your Honor. Good morning, Chairman Webb, Commissioner Tate, and Commissioner Anderson. My name is Sarah Tacker, and it is an honor to appear before you today and a privilege to represent Southwestern Electric Power Company, or SWEPCO. This case was filed on March 28, 2025, to address major capital investment made on behalf of SWEPCO's approximately 130,000 Arkansas customers. Those investments are consistent with the company's obligation to provide safe and reliable electric service to its Arkansas service territory. Those investments include the diversion and wagon wheel electric generating wind facilities, which add 799 megawatts of nameplate capacity, enhancing SWEPCO's diverse generation portfolio. The prudence of these facilities was established by the Commission in 2023, and this case is the company's first opportunity to include those costs in rates. The facilities went online, diversion went online, and commenced operation in December of 2024, and the wagon wheel facility will commence operation in the coming weeks, early December. These facilities represent approximately $320 million of generation investment for SWEPCO's Arkansas customers at a time when the demand for electricity only continues to grow. This case also addresses the increasing need for additional transmission investment through SWEPCO's regional transmission operator, Southwest Power Pool, or SPP. The case brings into rates the company's deployment of an automated metering system together with a correlating reduction to expenses for manual meter reading, as well as enhanced function and accessibility for customers. Rising costs across all areas of service have also contributed to the necessity of filing this case. This case has resulted in a settlement agreement joined by all parties to this docket except for National Audubon Society and the Sierra Club, who do not oppose the agreement. The settlement is a negotiated compromise addressing many of SWEPCO's critical needs while striking a measured balance for SWEPCO's customers, a concern shouldered jointly by both the company and the stakeholders here today. This matter has been thoroughly investigated by all the parties, and the company has provided transparent, documented justification for the relief that it seeks in this application. In fact, SWEPCO's initial application and testimony contained over 3,000 pages of documentation, with myriad unfiled work papers in the form of complex Excel spreadsheets supporting those 3,000 pages. In the last 6 months, SWEPCO has responded to nearly 1,000 formal data requests during discovery. That does not count subparts of the questions and the informal exchange of information with the general staff. This discovery yielded an additional 4 rounds of robust pre-filed testimony, with a total of over 45 witnesses appearing in pre-filed testimony. This settlement, seeking an $85 million increase in base rates, has been substantiated by the company and vetted by the parties to this case in a manner that the Commission can place a high level of confidence in the reasonableness of its end result. To those terms, the settlement reasonably resolves the difference of opinion between staff and the company as it relates to use of the used and useful concept and how that principle is applied to the retirement of physical plant prior to the end of its economic life, such as the Perky plant in this case. The principle should be utilized for identifying when items go into rates, not necessarily when they should come out. This precedent is described in Order Number 14 of Docket 21-070-U, starting at page 46. That order instead describes a fact-specific, case-by-case analysis to examine early retirements such as Perky. The settlement here and the facts in this case show that the early retirement of the Perky plant was prudent, and there are no other facts present which would warrant a return on that investment of 0. The settlement agreement is a reasonable compromise between the parties that is also consistent with Commission precedent. As the Commission can see from the record in this case, the company is striving to be responsive to its customers' priorities. It was able to resolve specific issues with both the University of Arkansas and the City of Fayetteville, a result illustrative of the company's commitment to engage in fruitful and responsive discussions. As the Commission can see from the settlement agreement, SWEPCO has withdrawn its request for a modified transmission cost recovery rider, or TCR, as well as its system improvement plan, or SIP. The TCR would have addressed steadily escalating transmission investment cost charged to the company through SPP based on its FERC-approved open access transmission tariff. SWEPCO believes that the withdrawal of the TCR is reasonable for the purposes of settlement. However, the settlement does not alleviate the company's need to address in some manner the $7 million increase in expenses in the upcoming year, or the additional $16 million in expenses that will happen in the following year, with additional further escalations forecasted in the years after. Now to the SIP. It is evident in a review of SWEPCO's yearly transmission and distribution enhanced reliability reporting that SWEPCO is prioritizing reliability in the operation of its system during normal conditions. With the SIP, however, SWEPCO sought to enhance the resiliency of its system, addressing abnormal conditions during extreme weather events. The record in this matter clarified the parties' position on cost recovery of that proposal, and it was thus withdrawn for the purposes of settlement. The company is hopeful, however, that continued future discussions can clarify the position of its customer and its regulator on whether and how to prioritize investment in the resilience of the electric system. Together with the Commission and the parties to this case, SWEPCO is also mindful of the rising costs across all sectors of the economy, which includes the provision of electric service. But even after this increase, SWEPCO's rates remain 20% below the national average, which continues to grow. SWEPCO does not take its customer service responsibilities lightly, and while this base rate increase is both reasonable and justified, it does not negate the fact that prices are increasing for SWEPCO and thus increasing for SWEPCO's customers. With an eye toward defraying the impacts of cost increases to customers, SWEPCO is pursuing a number of strategies. SWEPCO is aggressively seeking funding opportunities through the Infrastructure Investment and Jobs Act with both the Federal Department of Energy and the state's infrastructure coordinator at the Department of Finance and Administration. 2 separate grants have been secured to cover over half of the infrastructure investment for 2 major projects within the Texarkana District's distribution system. Both projects are in Sevier County and will benefit rural and urban areas in and around the city of DeQueen. SWEPCO continues to pursue additional grants as well as federal financing opportunities for the benefit of its customers. SWEPCO is excited to offer new customer programs through this case, made possible by AMS. These programs include a residential time of use tariff, a residential electric vehicle charging tariff, and the new prepay program, Pay As You Go. These programs offer opportunities for customers to both customize their electric usage to their needs and potentially reduce the expense of that electric usage. The Pay-As-You-Go program will offer customers a no-deposit method to begin or continue service with the company. AMS will also provide crucial visibility into outage details, a critical need when the company is diagnosing the reason for outages and directing resources to address those outages. The settling parties recommend the settlement agreement as in the public interest. It establishes just and reasonable rates. It allows SWEPCO the opportunity to earn a return on its prudent investment. SWEPCO is committed to its customers through the provision of reliable, safe, and affordable electricity, and this settlement enables the company to continue with that mission. Thank you for the opportunity to appear before you today. The company has filed the settlement testimony of Melissa A. Gage, Vice President of Regulatory and Finance, and we will present her later in the proceeding for any questions.
Thank you, Ms. Tacker. Mr. Nolan.
Thank you for recognizing me. I am Ross Nolan on behalf of Audubon, one of the non-settling parties in this case. Sierra Club, the other non-settling party, does join my statement today, if you will, pursuant to the Commission's previous orders in this case. Audubon submits testimony of 2 witnesses who each provided reports on their issues as exhibits to their direct testimony. The first, Casey Baker, testifies regarding the now long identified Northwest Arkansas load pocket. The second, Michael Goggin, addresses uneconomic dispatch at Flint Creek. Mr. Baker states that it is past time to consider alternatives to address the Northwest Arkansas load pocket. Both the Commission and SWEPCO have long identified the Northwest Arkansas load pocket as an issue now for well over a decade. A load pocket is an area where load exceeds or can exceed capacity. Due to the rapid growth in Northwest Arkansas, that issue has long been on the radar of both the Commission and the company. Mr. Baker states that SWEPCO must consider new and developing alternatives to address the load pocket, especially transmission improvements and emerging alternatives. Utilizing these improvements can address the rare peak conditions that SWEPCO cites as justification for continuing Flint Creek operations as they presently are. Mr. Baker suggests alternatives such as energy storage equipped with grid-forming inverters as a cost-effective means of creating an effective response to rare peak conditions. Grid-forming inverters allow for real-time responses to energy demands as opposed to static or existing inverters. So, for example, solar paired with batteries and grid-forming inverters could be deployed at the existing Flint Creek site. Mr. Baker proposes similarly straightforward solutions to the transmission issue, especially reconductoring or putting new lines on existing power transmission structure to replace those lines with high-performance conductors combined with advanced system support assets such as STATCOMs and SVCs. Mr. Baker's testimony is that each of these options must be studied, and after well over a decade of delay, the sooner the better. The options Mr. Baker identifies utilizing existing infrastructure at Flint Creek for solar production and battery storage, as well as reconductoring of existing transmission corridors. These solutions are not revolutionary, but rather are common sense use of existing infrastructure. Audubon supports the proposed SPP resource retirement study modeling 2030 and 2035 retirement of Flint Creek found at paragraph 32 of the proposed settlement, but asks that it be included as a party to the scoping and the other meetings and proceedings that will occur pursuant to that study. We ask to be a part of that study to assure that emerging technologies for production and transmission are included in the study. Without including these new technologies in the study, it will not inform future decisions well. So we're asking for a seat at the table to participate and make sure that Mr. Baker's testimony and the items and issues identified in his report are in fact considered during that study that is proposed. Our second witness, Mr. Michael Goggin, testimony addresses uneconomic dispatch at the Flint Creek facility. His analysis, documented as an exhibit to his testimony, indicates Flint Creek engages in uneconomic dispatch as much as 30% of the time between 2019 and 2023, resulting in approximately $4.6 million of uneconomically incurred costs during that time. Uneconomic dispatch occurs when a generating source is operated despite lower cost alternatives being available in the market. Generally, SWEPCO uses software to find least cost electricity or to determine when it will produce its own. However, SWEPCO can and does override that decision-making process to designate Flint Creek at times as must run. It does so in several situations, including testing, anticipated peak conditions, or coal pile management. Mr. Goggin recommends 3 actions in relation to uneconomic dispatch. The first is to increase transparency by requiring SWEPCO to report determining factors and the decision-making process when it chooses uneconomic dispatch. You will find that in paragraph 32 of the proposed settlement, but again, we believe that on the uneconomic dispatch issue, the Commission should go further in its final order in this case, specifically to disallow fuel cost recovery from uneconomic dispatch and direct the company to reject fuel supply and transportation contracts that lead to burning coal simply to manage the size of the pile on site. We believe the company can do better to engage in uneconomic dispatch less often by negotiating better terms for its fuel supply contract. While the proposed settlement, page 13, paragraph 3, proposes increasing reporting for uneconomic dispatch, we also believe it doesn't go far enough in that. We would like to see those numbers and those information about uneconomic dispatch to be easier to find, to make that information public, to inform the public and to inform those before the commission about when and why those uneconomic dispatch conditions occur. So simply increasing reporting on conditions that we are presently able to understand to a moderate degree of confidence with available information does not protect ratepayers from increased costs due to uneconomic dispatch. SWEPCO negotiates its fuel contracts, direct it to engage in a contract which does not unnecessarily create costs which SWEPCO then wants to pass on to consumers. The public should not pay for SWEPCO's poorly negotiated terms. More efficient fuel contract terms are available and used in other areas. This is a rate case. Disallow those costs. Change this behavior for the benefit of ratepayers in Arkansas. Thank you for recognizing me, Commissioners.
Thank you, Mr. Nolan. Mr. Bynum.
Good morning, Commissioners.
Good morning.
My name is Randy Bynum, and I will be giving the opening statement on behalf of the Arkansas Advanced Energy Association and the University of Arkansas System. The association, the Arkansas Advanced Energy Association, represents hundreds of advanced energy companies that employ thousands of Arkansans and bring billions of dollars in development to the state. The University of Arkansas System is the state's largest university system, consisting of 15 2- and 4-year campuses with multiple facilities throughout the state of Arkansas, several of which are SWEPCO ratepayers. We're here today to consider the settlement agreement entered into by most parties to this docket. My clients, AAEA and the university system, support the settlement because it addresses the issues raised in this docket in a manner within the range of reasonable litigation outcomes. The settlement benefits all SWEPCO customers and will produce just and reasonable rates. In the settlement agreement, the parties have agreed to a revenue deficiency of $85.4 million, which is a significant decrease compared to the revenue deficiency of $114.4 million originally sought by SWEPCO. Revenue requirement deficiency deficiency are based on staff's updated cost of service study, with some exceptions, including a return on equity of 9.65%. New base rates reflecting the agreement will be developed using staff's billing determinants, but with the revenue distribution methodology recommended by SWEPCO. SWEPCO is agreeing, as part of the settlement, SWEPCO is agreeing to withdraw its request for approval of the System Improvement Plan Rider and its request to amend and expand Rider TCR. The settlement also resolves numerous other issues, including the tariff issues raised by the university and the AAEA. These issues and their resolution are detailed in the settlement testimony by University System and AAEA witness Larry Blank. I'd like to highlight one issue that was clarified in the settlement. This was the issue of whether behind-the-meter generation is subject to the rules regarding net metering, even though it's not putting generation back onto the grid or receiving compensation for doing so. This was the subject of a motion by AAEA in Docket 23-21R. By the way, that motion's still pending, so if you want to take a look at it sometime. However, in SWEPCO's settlement testimony, they clarified that accounts with behind-the-meter generation that do not receive compensation for excess generation are not subject to the laws and regulations governing net metering. The settling parties vigorously debated the issues over several days, with all parties zealously representing their interests throughout the process. The issues raised in this proceeding were thoroughly vetted and considered throughout the settlement process. The settlement resulted from the natural give and take of intense negotiations which required hard work and ultimately compromise from each of the parties. Although the rate increase remains sizable, it could have been substantially larger if the case were fully litigated. Moreover, SWEPCO has invested capital in new plant additions, and its previous FRR revenues need to be rolled into base rates, which means that some level of rate increase is unavoidable in this case. However, eliminating the two riders, the SIP rider and the TCR amendment, protects customers against ongoing large rate increases after this case is adjudicated. Customers are also benefiting from concessions on tariff issues as detailed in Dr. Blake's settlement testimony, which improves the overall level of SWEPCO service. Finally, I would like to add that the settlement agreement is a product of vigorous debate and advocacy, but ultimately reflects compromise among all parties. Rates resulting from the settlement will be just and reasonable because the settlement is derived from a thoughtful and vigorous process in which all stakeholders were ably represented by their advocates. The settling parties crafted a balanced settlement agreement while grappling with many complex issues in this docket. In conclusion, AAEA and the university support the settlement and urge the commission to approve it. Thank you for your time.
Thank you, Mr. Bynum. Mr. Pennington. I want to disclose that Mr. Pennington, I knew him back when he was a high school student. That was a few years ago, and even though he was from Bryant and I am from Benton, I will do my best to keep that from prejudicing me in my decision.
I appreciate that, Mr. Chairman.
Thank you, sir.
Commissioners.
Welcome.
Blake Pennington on behalf of the city of Fayetteville. We are SWEPCO's largest municipal customer in the state of Arkansas, and we appreciated the opportunity to intervene and participate in these proceedings. The city's primary concerns, other than the proposed rate increase, which I think Mr. Bynum covered very well, were SWEPCO's continued investment in the Flint Creek Power Plant, addressing the Northwest Arkansas load pocket, and implementing clean energy solutions to help Fayetteville meet our climate action plan goals. We believe the proposed settlement agreement sets the parties on a path forward to examine the possibility of retiring the Wells Creek plant before its scheduled 2038 retirement, Flint Creek, track SWEPCO's self-commitment of the Wells Creek plant, and explore all energy solutions, including clean energy technologies, for the acquisition or construction of generation solutions in the future. We encourage the Commission to approve the settlement agreement as a reasonable compromise that is in the public interest. We have filed the testimony of Peter Nierengarten in support of the settlement, and he will be appearing before the Commission later. I appreciate the opportunity.
Thank you, sir. Mr. Chamberlain.
Thank you. My comments will be brief. Walmart did file testimony, as I indicated, of Ms. Lisa Perry. That testimony set out some concerns that Walmart had with the ask that the company made initially. Through the settlement negotiations, there was enough compromise that Walmart was able to sign on, and they did sign on, and they are supporting the agreement. They believe it's within the realm of reasonable outcomes of a litigated proceeding and will result in fair and just and reasonable rates. And that's all I have to add.
Thank you, sir.
Thank you.
Mr. Schrader. It is Schrader, not Schroeder, correct? Yes.
Yes, Your Honor. It looks like Schroeder, but it's pronounced Schrader.
I know Schraders and I know Schroders.
That's
okay?
right.
So
Good German name.
Thank you.
So Chairman Webb, Commissioner Anderson, Commissioner Tate, thank you for the opportunity to appear before you today. I've appeared before you, Commissioner Tate, numerous times, but I've not appeared before you, Commissioner Webb, or you, Commissioner Anderson, so I appreciate the opportunity. I'm honored to be here today.
We're much nicer than he is, okay?
So I am here on behalf of Western Arkansas Large Energy Consumers, otherwise known as WALEC, and my name is Tom Schrader. I'm legal counsel for WALEC. WALEC is an unincorporated association of large energy consumers with facilities located in SWEPCO's Arkansas service territory. WALEC was formed for the purpose of ensuring reliable energy supply and lowest reasonable utility rates for its member companies and for other similarly situated customers. The WALIC member companies that are participating in this docket include Goodyear, Domtar, George's, Pilgrim's Pride, Tyson Foods, and Washington Medical Regional Center. Now, as you know, the manufacturing and healthcare industries account for a substantial percentage of the Arkansas economy and provide employment to a large percentage of the workforce. WALIC members alone provide jobs to thousands of Arkansans to generate paper products, manufacture tires for automobiles, process and provide a lot of food products to Arkansans and others, and also provide medical care through member company medical facilities. So WALIC provides significant jobs to Arkansans, wages and benefits to their employees, and also pay significant taxes to state and local government. Now, why are we here? Well, WALIC member companies depend on reliable energy and reasonable cost energy to run their facilities in Arkansas. These facilities use significant amounts of energy, and they compete with facilities in other jurisdictions in the making and delivery of their products. So reasonable cost energy and reliable energy is a major focus for WALIC member companies. Now, following WALIC's review of the case that SWEPCO filed, WALIC decided to intervene and retain an expert witness, Mark Garrett. Mr. Garrett provided testimony in response to SWEPCO's rate hike. Now, SWEPCO's rate hike changed during the course of the proceeding, but at last note, the rebuttal rate hike would have, if you granted it, raised base rates by $124 million or by 71.96% for most of SWEPCO's customers. Now, that's significant. Such an increase, in my opinion, would have had a devastating impact on SWEPCO's large energy consumers and all other customers of SWEPCO. So one of WALIC's objective in intervening was to oppose the rate hike and ensure lowest reasonable rates for WALIC members and other businesses and industries in Arkansas. Now, in direct and surrebuttal testimony, Mr. Garrett addresses the $124 million base rate increase, and he recommended numerous downward adjustments to that revenue requirement. Those downward adjustments related to the cost of capital that SWEPCO was asking for, payroll levels, net operating loss carry forward reg asset, rider collection, and other important issues. So Mr. Garrett provides testimony regarding the impact of the proposed rate increase on SWEPCO customers and WALIC member customers. Now, Mr. Garrett notes that SWEPCO customers would have realized an average increase in their electric bills of approximately 21% from SWEPCO's rate hike request, 21%. We believe that that would have had a chilling impact on economic development and job growth in SWEPCO's service territory. So following the filing, as you heard, of all the testimony, the parties entered into settlement negotiations, and I will tell you, commissioners, they were robust settlement agreements. They continued for a week, and fortunately, they resulted in the consummation of a mutually agreeable settlement agreement. On November 7th, the parties filed that joint motion to approve the settlement agreement, and you've also received testimonies in support of that settlement agreement. As Ms. Tacker mentioned, and other attorneys as well mentioned, the joint motion urges you to approve the settlement as a reasonable resolution and as in the public interest. Now, in settlement testimony, Mr. Garrett provides the rationale for WALIC's support of the settlement agreement. Now, Mr. Garrett notes that the settlement agreement addresses each of the major issues identified by WALIC in its direct and sur rebuttal testimony. And Mr. Garrett also points out that the settlement reduces SWEPCO's base rate revenue increase from $124 million to $85 million. That's a significant reduction in the amount. The settlement also, as you heard, rejects SWEPCO's request for a system improvement rider and also rejects SWEPCO's request for changes to transmission cost recovery rider, all which would have had an additional impact on SWEPCO customers. The settlement authorizes a return on equity of 9.65%, which is a reasonable compromise, rather than SWEPCO's sur rebuttal request of 10.4%. I will also say the settlement adopts the capital structure proposed by staff, witness Mr. Marchand. And also the settlement updates the cost of service as recommended by staff witness Spadoni. So most importantly, though, all of these things result in an average bill increase to SWEPCO customers of approximately 9.4%, rather than the 25.4% that SWEPCO's rebuttal case filing recommends, including the rider. So while a 9.4% average bill increase is still significant, that increase is significantly lower than SWEPCO's requested average bill increase of 25.4%, and is a reasonable resolution. Now, finally, I will point to Mr. Garrett's testimony, which confirms that the settlement agreement produces a reasonable revenue requirement. And Mr. Garrett also testifies that the settlement provides for an equitable revenue allocation method. And so Mr. Garrett finally says that while reasonable and in the public interest, commissioners, as you know, Waylick and the other parties acknowledge that the settlement does not establish a precedent for future rate proceedings, and any methodology or rate treatment in the settlement is not to be deemed precedential for any future commission proceeding. So in conclusion, Waylick recommends and requests that you approve the settlement as being reasonable and in the public interest. Thank you so much.
Thank you, Mr. Schrader. Ms. Chandler for the AG.
Chairman Webb, Commissioners Anderson, and Commissioner Tate, on behalf of the Attorney General's Office, thank you for allowing me to address you all before the settlement testimony is presented. I want to take this opportunity to share with you how we got to where we are. While representing the interests of Arkansas ratepayers often involves litigation, this hearing involves the affirmation for the Commission that the settlement agreement is representative of the best interests of the ratepayers. There must be a balancing of seeking what is best against these rising costs while still maintaining reliable access to services. It's a fine, difficult line for everyone to navigate. Let's be honest, everyone sitting in this room is a ratepayer to some utility, and no reasonable person enjoys paying more than to turn that light switch on or for the heater to kick on. While no one enjoys paying more, it's more than a matter of dislikes to many Arkansans. It's a difference between food on the table and heat to keep their kids warm. Our goal in this proceeding is obtaining a result that provides the most benefits to the most customers under these circumstances. SWEPCO's completed case filing presented us with two key questions. Is a rate increase really necessary? And if a rate increase is necessary, what's the minimum amount needed for the company's continuation? I would love to be able to come in here and tell you all that there should be no rate increase and we all go home, but reality is I cannot do that under the facts that we were presented. Statutorily, SWEPCO is entitled to recover certain investments and costs. Their last increase in base rates was filed in 2021. Since that time, its base rate has grown by $661.4 million. It's continued to increase investments in generation, transmission, distribution facilities, including filing multiple dockets. It is evident that there's going to be a rate increase, shifting the analysis from should there be an increase to how much should that increase be. The review shifted to was the minimum amount of increase SWEPCO should be entitled because the approximately 27.9 increase to residential ratepayers in their application is unacceptable to us. As you all have seen, there are dozens of issues contained in multiple rounds of testimony. The AG's experts reviewed hundreds of pages of discovery, leading to testimony in support of significant adjustments to SWEPCO's revenue deficiency, request for denial of a system improvement plan rider, a requested reduction in return on equity, among other recommendations. Each issue brought about a robust debate between the parties, along with extensive discussions and negotiations resulting in this settlement. Why accept this settlement? In order to have lower increase in ratepayers' monthly bills than what is being proposed here, we would have to walk into a hearing and you all accept every aspect of our experts' testimony or other interveners' experts, and that's an improbability. Once again, in SWEPCO's application, the estimated bill impact on the average customer using 857 kilowatts per month was an increase of over 27%. This settlement substantially cuts that in comparison to the initial filing. In fact, this settlement is very close to the Attorney General's case laid out in our direct testimony. Additionally, the agreement further addresses specific issues of concern for ratepayers, providing for further benefits in the future. The highlights of those benefits are as follows. First, SWEPCO's originally requested rising base rates to cover revenue deficiency of $114.4 million, but this agreement reduces that amount by approximately $29 million. This cuts the company's original deficiency by almost a quarter. Second, SWEPCO's proposed 21.5 system improvement plan rider on top of the revenue deficiency. This settlement removes that from consideration, another $21.5 million removed from the application. Third, SWEPCO has agreed to set its return on equity at 9.65%, which is substantially lower than the requested amount of 10.9% and only marginally above the 9.5% recommended by our experts. An ROE of 9.65% results in substantial decrease of the company's proposed figures. Finally, SWEPCO agrees to withdraw its request to amend rider TCR. Settlements such as this one provide certainty and stability by giving a clear framework. It balances stakeholders' interests to ensure all options are considered. In sum, the substantially lower revenue deficiency, removal of the SIP rider, and substantial decrease in the ROE and withdrawal of the rider TCR amendments result in settlement agreements that is superior only to a summarial grant of everything requested in the AG's testimony. While no party was able to make a case that no increase in rates was appropriate, the concessions we were able to secure substantially cut the expected bill impact to the average residential customer and is in the interest of the public. Greg Meyer, our expert, will provide testimony in support of the reasonable and public interest of this settlement agreement. Thank you.
Thank you, Ms. Chandler. Ms. Kelleher.
Why is everyone taller than me? Okay. Thank you, Mr. Chairman, Commissioners Anderson and Tate. My name is Dawn Kelleher, and I represent the general staff in this matter. Before you, for your consideration, is the motion to approve the joint non-unanimous settlement agreement. After lengthy and exhaustive negotiations, the settling parties, including SWEPCO, the Attorney General, the Western Arkansas Large Energy Consumers, Walmart, the University of Arkansas System, the City of Fayetteville, Advanced Energy Association, and staff, reached this agreement settling all the issues in the docket. In addition, the non-settling parties, Audubon and Sierra Club, have stated that they do not oppose the settlement. The settlement is based on the recommendations set forth in staff's rebuttal testimony as adjusted for additional items described in the agreement. The main driver of the rate increase in this case is the inclusion of approximately $665 million of new plant in service, mostly attributable to the diversion and wagon wheel wind facilities, which were approved by Order Number 5 in Docket Number 22-019-U, and Order Number 10 approving the amended settlement agreement in Docket Number 22-019-U. These facilities add approximately 800 megawatts of clean energy to SWEPCO's generation portfolio, benefiting Arkansas ratepayers. In its application, SWEPCO requested a revenue requirement of $403,967,696 based on a revenue deficiency of $114,434,550, indicating a 39.5%, a 39.52% increase over existing base rate revenues, inclusive of approximately $30 million of formula rate review rider or FRR revenues. Using its traditional methodology, staff recommended a revenue requirement of $362,366,702 and a revenue deficiency of $106,948,224, excluding FRR revenues from current revenues. The settlement agreement revenue requirement, which includes the FRR revenues and other revenues of $40,726,528 is $370,420,101 or $8,053,399 more than staff's recommendation of $362,366,702, but is $547,595 less than the company's application. The parties endeavored to provide full transparency to the rate increase with the attachments to the settlement agreement. The Settlement Attachment 2 was included at staff's request for informational purposes to provide clear picture of the terms of the magnitude of the rate increase as it relates to an increase in base rate revenues with and without rolled-in rider revenues, including FRR revenues. The settlement revenue requirement and revenue deficiency are based on staff's updated cost of service study filed on November 7th, with the exception of the treatment of account 370 meters, which will continue the treatment approved by the Commission in Docket 19-008-U. I'll highlight some of the adjustments made to staff's rebuttal, which are included in the settlement agreement. The settlement return on equity of 9.65% was adjusted from staff's rebuttal testimony. However, the 9.65% is well within witness Michael Marchand's range of reasonableness and is below his midpoint, acknowledging the risk differential afforded to utilities in the Arkansas jurisdiction, as explained in his testimony. The settling parties agreed to a recovery period of 10 years at a 3% return, which is below the company's incremental borrowing rate on the Perky plant from staff's position of a 20-year recovery period with no return, and SWEPCO's request of return at the weighted average cost of capital. The settling parties agreed to continue treatment of the automated meter reading at the Lone Star plant, which was established in Commission Docket number 19-008-U. Staff had previously removed the remaining net book value of the AMR meters and Lone Star plant and a return of those costs over 12 years with no return on. SWEPCO argued that the savings adjustment staff made to correct the original calculation associated with the COVID-19 deferral is not allowed. Staff disagrees, but for settlement purposes agreed to forego those savings in the final amount and continue the amount agreed to in docket number 21-070-U. Coal inventory was adjusted to a compromised full daily burn rate amount from staff's 23-day recommendation and SWEPCO's 35-day ask. SWEPCO provided a persuasive argument in Sir rebuttal for all but 5 days disallowed by staff. Staff disagrees, but for settlement purposes agreed to the 30-day burn. In docket number 20-012A, the Commission did not provide for any further recovery related to COVID-19 or over-under bad debt regulatory asset or the normalization of such asset. Staff's rebuttal recommendation was to disallow over-under bad debt amortization. For settlement purposes, staff agreed to amortization over 5 years of the under-recovery associated with the deferral payment arrangements for the 18-month period occurring between 2021 and 2022. Staff accepts for the purposes of settlement the company's treatment of factoring-related amounts in working capital assets. Factoring for current accrued and other liabilities were removed by the company in the application, and staff agreed. Staff's removal of Perky Perky operations and maintenance expense was made in error but was not discovered before sole rebuttal filing, so staff agrees with the settlement term. Finally, there were numerous changes to SWEPCO's tariff, which are set out in the settlement agreement, but I'll highlight the two that SWEPCO withdrew for purposes of the settlement. The first was a proposed change to the transmission cost recovery rider, or rider TCR, to include potentially substantial increases in transmission fees from Southwestern Power Pool. Staff consistently opposed this proposed amendment in favor of addressing these increases in a separate docket so the facts could be fully fleshed out. Second, staff consistently opposed SWEPCO's proposed System Improvement Plan Rider, or SIP, based on inadequate support for the project. The company withdrew its proposal for the purposes of settlement. The implementation of these two riders could have resulted in an additional $130 million in costs over the next 3 years. The result of staff's resolve related to the denial of these two riders is to eliminate or delay additional increases in the face of an already substantial rate increase in this case. Staff believes that the settlement is reasonable and in the public interest, and therefore recommends that the Commission approve the settlement without modification. Thank you.
Thank you, Mr. Kelleher. Now is the time in which we would normally have public comments. No member of the public has signed up for a comment, but we will give that opportunity to anyone in the room who wishes to make a comment. We appreciate all of your not volunteering. Thank you. Ms. Tacker, you may call your first witness for SWEPCO.
Thank you, Mr. Chairman. SWEPCO calls Melissa Gage to the stand. You had mentioned during the hearing procedures a bit earlier, sir, that you would like us to identify the testimony and the date filed. SWEPCO has 106 documents filed in this, and I am happy to read off each one to you, but am happy to also forego that opportunity if you would prefer.
We'll take judicial notice of those, okay?
Yes, sir. Thank you.
Thank you.
Ms. Gage, please state your name and position for the record.
Good morning, Chairman and Commissioners. I'm Melissa Gage. I'm Vice President of Regulatory and Finance for Southwestern Electric Power Company.
You're going to have to get a little closer to
Closer.
the mic. Yeah,
I'm usually not told I'm not loud enough, but
That's all right.
I can do it.
What is your business address?
400 West 15th Street, Austin, Texas, 78701.
On whose behalf are you testifying?
SWEPCO.
Are you the same Melissa Gage that filed direct testimony on March 28th and errata to direct testimony on July 11th, rebuttal testimony on September 19th, and certiorari rebuttal testimony on October 24th, along with settlement testimony on November the 10th?
Yes, ma'am.
Do you have any corrections to that testimony?
I do have one correction to my settlement testimony. So I'll take you all to, in my settlement testimony on page 14, looking at line 13, the sentence currently reads, a customer will be allowed to claim best bill for any one of the 12 months during the first year of the customer's subscription under the time of use tariff. And the words one of the should be struck from that language. This was just transcribed incorrectly from the settlement agreement over into our testimony.
So would you read it with that struck out?
Yes, sir.
Okay.
So it should read, a customer will be allowed to claim best bill for any 12 months during the first year of the customer's subscription under the time of use tariff.
Thank you.
Mr. Chairman, I tender the witness for questions from the commission.
Thank you, Ms. Thacker. Mr. Tate, I understand you wish to ask first.
Good morning.
Morning.
Since you corrected that testimony, maybe we'll start there. Can you explain exactly how that works so they can claim best bill for any 12-month period during the first year that they're using that tariff?
Correct.
So they can look back before they were in the tariff?
They would elect to be on the time of use tariff, and they'll be able to see on their bill whether, whether they would have been better off under the time of use tariff or not. And then they can at one point in time come back and ask us to best bill and bill them for that 12-month period using what would have been better for them.
So just so I understand, if, say they're in month 3, they can ask for best bill and it would incorporate the 9 months before? And alternatively, in month 11, they can look, and how does that?
Okay, so
Does
here's
my
where
question make sense?
it does make sense, and I have Miss Lynn Ferry Nelson here with me, and
Okay.
she is far more in the weeds on this, and so she's coming up right after me, and she might be able to better clarify that for me, and it might be better if I don't
Okay.
try to.
Yeah, we can
might-
wait for her. I want to look at errata HSPI attachment 1. Now, Ms. Tacker may have to correct me. This is on pink paper, but as I understand it, only certain parts of this are HSPI. Is that correct?
Yes, Your Honor. The items highlighted in turquoise
Yes.
are HSPI as they would indicate specific customer details. The remainder of the document is public.
Well, I don't want to make you testify, Ms. Tacker, so I'll point this to Ms. Gage, and if she needs your help, I'll let her tag you in. What's highlighted in that document relates to a specific rate class. You're saying it would release customer information. Is it because there are so few customers utilizing that?
Yes, Commissioner Tate.
Okay.
There are either 1 or 2 customers, and the information can be extrapolated from the data.
Okay, that's helpful. Thank you. So I'm specifically looking at the errata. As I understand it, what was inadvertently left off. So what is included in the errata is 2 additional boxes, I think, on the bottom right of the page.
My understanding, and I don't have the original version in front of me, but when we were looking at this yesterday, we realized that the very last column on the far right, total bill percent change fuel at current fuel, was inadvertently left off. It was in the native file, but when we printed and provided this, it was left off. But the numbers did not change.
So obviously the numbers are different, but can you tell me, and again, these are not HSPI, correct, Ms. Tacker?
Yes, sir.
Can you explain to me the difference between the two, the total bill percentage change, fuel at initial filing, what that means as far as initial filing, and the total bill change at current fuel?
Yes, sir. So I think the easiest way to explain this is if you look at, there's 2 columns in the middle that are titled as filed fuel revenue and then fuel revenue, if you see those in the middle. If you come down to the bottom where it's total firm retail, you'll see that as filed fuel revenue, which means when we filed this rate case, our ECR was collecting $110 million in fuel. We filed this case in March. We knew we were going to be updating that ECR and that fuel costs were going to come down. And that's what that $76 million number in the next column shows you, the new ECR that we filed in March of 2025. Those lower fuel rates were implemented in April of 2025. And so to give you the proper view of what a total bill percent change is, because customers bill a large portion of that is fuel, obviously. And so that significant reduction in fuel, we didn't want it to be misleading. And so we wanted you to be able to see that. And so the very last column is the percent change at current fuel, the fuel that the ECR that we filed in March that implemented in April. In the column to the left of that is the fuel at initial filing, the fuel charge that was in effect on the day we filed the case.
So I believe you included a bill impact in your settlement testimony. Is that, or
Yes,
is
sir.
that from somewhere else in your testimony?
It
Was
is.
settle-
It is in my settlement testimony.
Okay. And that is based off the total bill percentage change fuel at initial filing? It's limited, obviously, to residential and what we consider, or what has been considered a traditional or average residential customer, right?
Correct. Well, it's at 1,000 kilowatt hours per month, and our average Arkansas customers closer to 850, but just for the sake of ease, we used 1,000 here.
Okay. What, sorry, I thought I had that highlighted in here. What page is that on? in your
That is on
settlement?
page 20. It's lines 5 and 6.
So again, that's based on the total bill percentage change fuel at initial filing, correct?
That $17.51 reflects the settlement rates as well as the reduction in fuel from when we initially filed to today. What might help, because I thought about this and I know everyone was throwing out a lot of numbers in that opening statement, and I think what might help is if I try to walk you through the apples to apples of the numbers, if you'd like me to do that.
Well, I guess I'm wondering, so you guys updated this to provide what would be the change given current fuel? Why that's not the more appropriate number to look at, given that that's the current fuel, what was done with the updated ECR versus what was fuel at the time you filed the application?
Right, and that's why we presented both, because we did not want to be misleading. Because I would have to agree with you that if I was a customer sitting here today and the bill I get today represents the current fuel they're being charged today, not what they were being charged the higher amount when we initially filed the case. So you are correct that that's what that 1751 is. If you want the number, are you asking me what the number would be based on fuel today?
Well, just so I'm reading it correctly, can you tell me what the percentage change for residentials would be with the fuel rate as today? It should be in that errata filing, but I want to make sure I'm looking at the right number.
Correct, it would be 23%.
Okay. So a 23% increase for residentials based on today's fuel.
Correct.
And do you know what that translates to as far as a dollar per month figure?
Yes, so give me 1 second to make sure I get this correct. So under the settlement agreement, the bill change without the system improvement plan dollars, that would be $24.32 at current fuel.
One more time, 24, did you say $24?
Yes, sir.
Out of curiosity, when you guys present this to show bill impact for customers, why is the initial filing number used and not the current fuel number?
Look, given the timing of this case, when we filed the rate case, that was the fuel that was in effect at that point in time. And so while this case was pending, fuel was updated. And so we were trying to give you what customers are actually going to feel with that total bill impact.
So it was updated in April, is that right?
Yes, sir.
And your settlement testimony was filed 9 days ago, but you still used the initial filing number?
Yes, sir, for an apples to apples comparison. To compare the bill impact under the settlement to what we had initially filed.
Sure, that's helpful for us, but I think that number specifically is meant to give customers an idea of what's coming if we approve it, right?
I would agree with that, Commissioner. Our problem was when we initially filed the case, we were giving you the fuel that was in place at that time. And that is why we gave you these two columns, which I will admit is a little difficult to work through, but we wanted to be transparent and give you both numbers.
Well, I appreciate that you updated it before the hearing today. Do you intend to update that number I'm trying to think if there would be a place for you to do so in your compliance filings if we approve the settlement?
I would have to defer to council, but if the commission would like for us to update this number to be more clear, we can certainly do so.
Well, we didn't have any public comments today, but I'm sure as you're aware, we had quite a few comments filed in the docket. I think last look was 157, most of which point to affordability issues, which shouldn't come as a surprise to anybody in the room. I think we're going to get a lot of questions, and I imagine SWEPCO will get a lot of questions. If we approve the settlement, why their bills look different than what they thought the increase was going to be based on what was filed here, right? What was shown as kind of an average bill and what they should expect as an increase.
Understood. If they were comparing this number to what they saw today versus
Right.
comparing this number to what they saw when we initially filed the case, we were intending to be transparent with this, but your point is well taken.
I don't think you were trying to be misleading, not intentionally. That's not what I'm suggesting here. I do think transparency is important, and I think a customer is going to look at the increase from the bill prior to any decision we make and post decision any decision we make, not necessarily what was my bill before you guys filed the application.
Agree. And I will say, not to further confuse things, but come next March, we will also update our fuel
Sure.
again. And that number may go up, it may go down. We're putting these wind facilities in service, and those will come with production tax credits, net energy revenues in the market that will all flow through fuel to customers. So even this number we're giving you today could be different come March and April of next year.
So I know we've got a number of your colleagues here to help answer some of these questions. So you were designated the settlement witness, so I'll start with you. If you think they're better answered by somebody else, feel free to point me in that direction.
I will not hesitate to bring in my backup.
So I had some questions exactly on what was agreed to in the settlement agreement as far as a couple of the rider proposals that you had. So I think for purposes of settlement, you withdrew your amendment to the TCR. Is that correct?
Correct.
What is the intent there? Again, I think it was labeled as for purposes of settlement. You're not suggesting that you won't seek changes to that in the future, similar to what you've proposed here, but just it's not going to be part of this agreement.
Correct. I will say broadly, we are very aware of the impact that our bills have on our customers, and we are sympathetic to that. And we heard from all of the parties in this case that this was a large rate increase. And in recognizing that, we looked at these riders, and these transmission costs are going to come. They are costs that are billed to us by SPP, and what we were looking to do was what we thought would be more efficient was to better track those and be able to pass those to customers as we are incurring them, as the various entities in SPP are building out the transmission system. But there was a lot of pushback on that, both during the case and in the settlement discussions. And so in recognition of that, we did withdraw it from this application. We are obviously going to have to address that at some point in time.
Any idea when?
We are open to suggestions from the commission. If we could bring a standalone filing for a rider, we could bring a rate case. We're open to feedback on what the best way is to recognize that those transmission costs are increasing and how to address them.
Another rate case? I would assume that's not the preference of the company.
But I would not say that our preference is to go through this full process.
Do you remember how many rate cases SWEPCO has filed in the last 6 years? Specifically in this jurisdiction?
So let me think. I have been in this role for about a year. I know we filed one in 2021. I believe we filed one in 2019 before that. And then I believe there may have been one before that, but I do not recall. At least two, dating back to 2019.
So this is at least your third in that period of time.
Yes, sir. I mean, I will note there has been a significant amount of investment in our system that has driven us to need to file these rate cases.
I'm probably going to inadvertently call it the SIR rider because it's System Improvement Rider, but I think the parties have designated the SIP rider. Is that right?
Yes, sir.
There was a commitment, you're withdrawing your request for that rider as part of this agreement as well, right?
Correct.
What is the intent there?
Similar but different. Those are costs that we think are important for us to go incur to be able to make our system more resilient and better serve our customers. However, unlike the transmission costs that are coming to us from a third party, the system improvement plan is something that we were bringing to the commission, and we would really like feedback from you all on what the correct balance is in making the system more resilient and more robust and providing more reliable service to our customers, and what that bill impact is going to be on customers. We think that all of that work is important, and we would like to go do it. But if the commission and our customers who are in those settlement meetings are telling us that they don't think that that is where we should be spending those dollars, then that's not something that the company is going to do. So we would like feedback from you all on how you would like us to proceed in terms of the balance between affordability and having a more resilient system.
That's primarily upgrades or additions to the distribution system?
Yes, so the first part of our system improvement plan is primarily vegetation management. In order for our teams to go in and do the work to harden the system, they have to go in and get at the vegetation issues that we have. And so initially there was a lot of spend on the vegetation management side as part of the plan, and then they would come in behind that and harden some of the system to make it more resilient.
So you have a transmission rider. I think you've indicated a desire for a generation rider related to legislation passed recently. You're opting into the formula rate rider, and on top of all of that, you want a separate rider just for distribution resilience projects?
Well, that is accurate. I would clarify that our transmission rider currently, the costs that are included in the transmission rider are relatively flat. And so it doesn't track the costs that are increasing from SPP. And while we may choose to try to use the generation rider, the facilities that are associated with that have not even been approved by the commission at this point. I mean, we do hope to bring that for you all to approve soon, but we are not there yet. But that is a correct way to characterize it.
Well, we seem to be moving in a direction of a separate rider to recover nearly everything, but I'm not seeing the pace of rate cases drop off either. So we've had 3 in what appears to be 6 years, plus now individual recovery riders for what would seem to encompass nearly everything at this point, generation to transmission to distribution, plus the fuel riders.
I hear what you're saying. What I would disagree with is that on the generation side, the $1.7 billion that the company spent on diversion and wagon wheel, we do not have a generation
Sure,
rider
those
for
were
that.
before that act was
So,
implemented.
I mean, candidly, this rate case was driven by and timed due to those resources. If we had a generation rider, you know, I don't know what the numbers would have looked like, but perhaps this rate case would have been different. And on the transmission rider, it's not tracking our costs. And so we have to come in for a rate case in order to pick up those costs due to the 4% cap on the FRR.
So to that point, and the fact that there was not a generation or a rider to recover those generation costs before, do you anticipate then less of a need for rate cases as frequently in the future?
If we were able to recover generation costs through a rider and we were able to better sync the transmission rider, the costs that are coming to us from SPP, and able to better track those, I do think that would alleviate some need for rate cases.
So recovering all those costs through riders, what benefit does that provide to the company? Why are we doing it that way?
I think in doing it that way, you're helping us ensure that the company is financially sound and that we are able to make the investments needed timely to be able to better serve our customers. If there's uncertainty about cost recovery, then that makes it more difficult for us. And by having that recovery of costs, we have an indication from the commission what your priorities are and how you would like for us to be spending dollars to ensure that we're providing customers with the service that's expected.
So with the formula rate specifically, it reduces lag, right, between investment and recovery?
I would agree with that, subject to the 4% cap, yes.
And it as you mentioned, provides some level of surety about recovery as well. So I would imagine that also affects risk, right? It's more riders, less risk, generally speaking.
I think there is still some level of risk because we are making those investments and they're still subject to the commission's prudence review. But in terms of the timing of that recovery, it does help with that. Yes.
So how does the settled ROE take that into account?
The settled ROE of 965 is well below the company's SIR rebuttal position of 10.4% and just a slight increase over the 9.5% that basically staff and the other interveners were all looking at. It's still well within staff's range and still at the low end of staff's range. And so we do think that it's an appropriate compromise, particularly when you couple it with the reality that in accepting staff's SIR rebuttal case as our starting point here, SIR rebuttal case, that accepted staff's cap structure, which, not to start a fight with Mr. Marchand here, but we've still continued to fundamentally disagree with his opinion on cap structure, but we accepted that as part of the compromise here with that ROE.
So that's the nature of a settlement, is compromise. But as you mentioned, Mr. Marchand said in his testimony, the settlement ROE recognizes the unique recovery mechanism allowed in Arkansas but not allowed in most jurisdictions, in which electric utilities that comprise the risk comparable sample operate. Essentially, one rider specifically that's available in Arkansas reduce risk to the company. And I think it's his testimony that the rider, the ROE that was agreed to, encompasses that. Is that your understanding as well? Takes into account that reduction in risk?
I think you would have to ask him exactly what his opinion is on that, but I will say I think that the company disagrees with the characterization that the generation rider allowed in Arkansas is not allowed in other jurisdictions. In SWEPCO's own jurisdictions, we have generation riders available to us in those states. So I would disagree with that premise.
You would disagree with the premise that it's not available in other states, but would you disagree with the premise about its effect on risk?
If we were certain that we were going to use that generation rider and that the commission was going to authorize our collection of costs through that rider, then I could see that potentially being something that I would concede to as we sit here. But the reality is those generation facilities have not been approved by this commission, and we have not sought to include them in a rider and rates at this point in time. Now, maybe in some future case, if the commission were to go down that path, that might be something to address at that point. But as we sit here today, there is no reason to put a lower ROE on the company for something that may or may not happen in the future.
So because those are still pending and you're not sure whether you'll be allowed recovery through that rider, you're saying this ROE that you agreed to as part of the settlement agreement doesn't encompass that change to risk for the company. So would that mean we should revisit ROE if we were to approve that? And if you bring back to us the SIP rider in the future, does that not have a similar effect? Should we consider changing the ROE at that point? At what point, as we add riders, should we start looking at the ROE?
So I will say, I'm not a lawyer practicing here in Arkansas, but my understanding of that legislation associated with that generation rider was that it did not instruct the commission to lower ROEs based on the use of that rider. So we fundamentally disagree that those two things are necessarily paired together. I would agree with you that riders do help give the company more timely recovery of our costs. However, this ROE in this case was based on a settlement and a compromise, and I think you would have to ask staff and the other witnesses why they felt like this was appropriate.
So the words you used were interesting in describing that. You said the legislation doesn't, did you say instruct the commission to lower an ROE based on utilization of the rider?
Well, direct or contemplate. I don't think it speaks to that issue.
Does it prohibit the commission from doing so?
Not to my knowledge.
I want to shift to the Perky plant. As part of the agreement, the parties have agreed that the retirement of Perky was prudent. Is that right?
Yes, sir.
Give me just a moment. I'm flipping back through the settlement agreement. Also as part of their agreement, so it's return of the investment, but also a 3% return on the investment. Is that correct?
Correct.
So 3% is a nice round number. How did we reach 3%?
So without disclosing the confidential settlement negotiations, 3% is an amount in between 0%, which some parties were arguing for, and the full weighted average cost of capital, which is what the company was seeking in our initial filing.
Also, as part of that agreement, you're accelerating the period for recovery, right?
Correct. In our initial filing, we were recovering at our weighted average cost of capital over 20 years, and what we're proposing in the settlement agreement is 3% over 10 years.
So as part of Ms. Tacker's opening, she seemed to frame the issue as that there's no reason why a return on the investment should be prohibited or shouldn't be allowed. Correct. Is that the company's position? Is that the default is that there is a return on that investment even though it's not used and useful anymore?
Correct. I mean, my understanding of Arkansas precedent is that if the company has made a prudent decision, there's no reason to disallow costs. And with the exception of one party in this case who has now signed on this agreement finding the retirement of Perky prudent, no one has argued that the company did not make a prudent decision and that that decision was in the best interest of our customers. And so because of that, we do think it's appropriate to get a full return. But as a compromise, we agreed to this lower amount.
Have we done that with other resources that the company's retired?
So in this case, one of the things that came up was the Lone Star plant that the company, there's a small balance on the Lone Star plant. It is still being recovered at a full weighted average cost of capital, to my knowledge. Similarly, in the prior docket, I believe Welsh Unit 2 was recovered, the return on, and then of, I believe the return of it is being recovered at the company's incremental debt rate.
What about Dole Hills?
So Dole Hills was addressed in the company's last case, and in order number 14 in the last case, the commission authorized us to recover the net book value of Dole Hills, but not on Dole Hills. However, I think if you look at that case, the commission specifically did a fact analysis of that and had questions about the mine that was, commitments that the company had made related to the lignite mine that was serving that plant. And because of some of that uncertainty, the commission, I think, landed on the conclusion that a return of that was appropriate, but not on. But those kind of circumstances are not present here with Perky, and no one has made those allegations.
I think that's important for what is kind of the starting point when we're looking at plant retirements. Again, I think it's the company's position that it return on is kind of the starting position, and then a fact analysis needs to occur if you're not going to allow it, right?
I think I would agree with that.
So not the opposite where return of the investment is allowed, but if you're going to allow return on or continued return on that investment, a fact analysis needs to be done to differentiate it from other resources where it was not.
I think we would agree with that because all of that is under the premise that we built this plant, we placed it in service, it has been serving customers reliably, for Perky in particular, for 40 years. And then we found ourselves in a situation where, based on the analysis, it was no longer economic to run that plant. But no one was saying for the past 40 years it was not a prudent decision that, you know, that this commission also agreed to back then. And so we do think that that's the appropriate starting point. Yes, would be a shorter answer, sir.
So why is the return effective October 15th of 2024?
Good question. So in SWEPCO's last FRR, we agreed to move Perky, the reg asset, out of the FRR. So Perky was not being included in the FRR, and so that 3% is moving forward from that point in time.
Oh, that's the date. Okay, that was the date it was moved. That makes sense. There was also a reference to a portion of the return being deferred or addressed in the next rate case. Can you speak to that?
One second. I may need to clarify that on a break with someone and get back to you so that I don't misspeak, if that's okay.
Sure. You see what I'm talking about in the
Yes, I
agreement,
think
though.
I know
Okay.
the answer, but I don't want to misspeak, so I want to make sure I get
Okay,
it correct.
or if you want to tag somebody else in later to answer it,
Yeah.
we can go that direction
The
as
person
well.
I need to ask is not a witness, so I'm going to try to avoid that for them.
So I'm looking at page 19 of your settlement testimony. Where you say the settling parties agreed to mitigate the impact of the increase between the classes by assigning the overall base revenue system increase across the classes. Can you explain what you mean?
Yeah, so what we were saying here was attempting to distinguish from essentially how the company had initially proposed rates, which was different than what we have agreed to among the parties, which was to apply the increase equally across all of the customer classes, as opposed to when we filed the case, we made a few changes to that. For example, if a certain class would have gotten a total bill decrease, we moved some dollars in the cost allocation around in our initial filing. But under the settlement agreement, it's just an even spread across the classes.
You also state that compliance tariffs for new base rates and other tariffs reflecting the agreement will be developed using staff's billing determinants, but the revenue distribution methodology as recommended by company witness Jackson in her Sir rebuttal. We've obviously excused Ms. Jackson from the hearing today, but can you elaborate what we're talking about as far as the revenue distribution methodology?
Yeah, so I think the revenue distribution methodology is referring to essentially what you're looking at in errata HSPI attachment 1, how we're spreading those dollars across the classes, as opposed to using staff's billing determinants, which using staff's billing determinants had an impact, a negative impact to the company in terms of the dollars being recovered through the revenue requirement. And how we were reflecting current base revenues was.
Okay. I just want to circle back briefly to the SIP rider. Has the company experienced any load shedding events in the last 24 months?
Yes, sir, we have.
And can you talk briefly about the cause of those load shedding events?
Yes, sir. So earlier this year, we had 2 load shed events in our Shreveport area. The second one that was more impactful that I think we have heard about a lot more recently and you're aware of as in your role at SPP was related to a day where the weather was warmer than expected, and we had plants that were running, but based on SPP's forecasts, they weren't picked up to be dispatched, and so those plants shut down. And then we found ourselves in a situation later that day where there was not enough voltage support on the lines, and we acted as quickly as possible to get those plants back online. But unfortunately, we had to shed load at SPP's direction in that brief period of time.
So it was probably, if I understand what you're saying, a mix of things that ultimately was the cause of that event, but it sounds like all of it was either generation or transmission related?
It was generation and transmission related in the sense that, SPP is looking at the forecast and they thought they had the voltage support available in that area at that time. And then ultimately, as things began to deteriorate, we realized that we did not. And so.
But that situation specifically wouldn't be addressed or isn't necessarily contemplated by what you intend to use that rider for. That's not the type of resilience projects you're envisioning.
I wouldn't say that the SIP would be directly related to those types of events, no, because the SIP is more directed at hardening our system, doing the necessary veg management, and then hardening the system to better withstand extreme events, whereas the load shed events that you're referring to were related to more to RTO issues.
And the kind of things you're talking about, like vegetation management, is currently recovered through, or without this rider would be recovered through the Formula Rate rider?
Correct. Through base rates, we have probably about $6 million in base rates for veg management currently, and we're looking to increase that.
I think that's all I have, Chairman. Thank you.
Ms. Anderson?
Thank you, Chair. Excuse me. Thank you, Chairman. Ms. Gage, so I understand and appreciate the business case that you're making today for the rate increase. But this is your third rate increase in 6 years. It is a significant rate increase. It sounds as if you all might be back sooner rather than later. So I want to talk about your customers. I want to talk about the impact that this has on their everyday lives. This is a line of questioning that I have asked other utilities about in other rate cases, and it's something that I'm concerned about, and I want us to have that dialogue here today. The last numbers I saw, the average income for households in Arkansas is approximately 25% lower than the national average. We have had hearings recently where we have had public comments. There were a significant number of public comments made in this case. There's a similar theme in those comments. And I suspect we will hear more of that in the 2 public hearings we have coming up in this case the week after Thanksgiving. I want to know what the company is doing for some of those customers, particularly the ones I mentioned early with the percentages, your lower income customers. What are you all doing for them? What is your plan for those particular customers in light of everything that's going on right now? It's a time right now where prices are increasing across the board. We're surrounded with price increases, everything, groceries, everything. The customers that are focused on putting food on the table at night, what is SWEPCO doing for them, and what is your plan there?
So we have proposed several initiatives in this case. Well, let me take a step back and say everything that you were saying is not lost on us. And we have been given the opportunity by this state and this commission to serve our customers, and we have the obligation to reliably serve them, and we try to do that in the most affordable way. And I hear you that this is our third rate case, but as we just discussed with Mr. Tate, We don't have riders currently in place, and so our ability to do that is through a base rate case. You know, coming here today, we have invested $3.3 billion in our system since we were last here.
And I understand and appreciate all of that from the
Okay.
business side, but there is another side to this
No,
that we need to talk about.
Understood. And so we have several initiatives. We're doing time of use rates in order to help customers be able to better have a handle on their usage and potentially lower their bills. We're implementing what's called our pay-as-you-go program that Ms. Ferry Nelson can tell you more about. But essentially what that allows customers to do is pay as you go. And so they can better manage their usage. And what they're able to do is if they have a large deposit, if they enter into the pay-as-you-go program, their deposit can be used towards their bill so that they no longer have to have a large deposit, which we understand can be cost prohibitive for customers at times. So they can get on that pay-as-you-go program both without a large deposit, and if they do have a deposit, that deposit can be applied towards their bills.
So is Ms. Ferry Nelson the person to walk us through those two programs?
Yes, ma'am.
In detail?
Yes.
Okay, and we can do that with her in a moment, but go ahead, thank you.
Yeah, so in our AMS system is, you know, allows us to help with those time of use programs too. And we are constantly looking for grant funding to be able to make all this investment that we need to maintain our system, to meet the standards that are expected of us without having to flow those costs to customers. I mean, we are truly doing everything we can to try to lessen that impact.
So that's high level, and I understand we can get into some details later, but as far as, is that the level of detail you can give me? Do I need to go to one of your other witnesses for anything more detailed than that?
Yes.
And that's okay if it,
Yes.
okay, all right. Let me see, I may need to save the rest of this for her, just a moment.
Take your time.
I mean, I suppose I could add also, we have energy efficiency programs that she can discuss with you in more detail also.
Sure. Let me ask you this question, and we can circle back later. If the commission were so inclined to ask you, to ask SWEPCO to provide us with a report, thinking through, you know, maybe annually, I don't know yet. I'm still working through those details as well. As far as customer numbers, those folks that are in arrears, disconnection numbers, things of that nature, would you be willing to commit to do that?
Certainly. If the commission would like to see additional information from us, I'm sure we would provide it.
Okay, thank you. I'm going to save the rest of my questions for another witness.
Okay.
Thank you.
Thank you.
I do have some follow-up. Do you have some questions?
Go right ahead.
Okay. I have some questions about the AMI meters. Are you the right person to answer those, or do you have somebody else? You
Poor
want to
Ms.
point
Ferry
to?
Nelson, but those are probably going to need to be directed to her, but I can try.
Do you have a general idea of how many opt-outs there have been with the deployment of the AMI meters?
I think that number is low, but she should be able to give you that number.
Okay. And what about a rough estimate on the savings customers have received because of the deployment of the AMI meters?
I'm recalling a number in her testimony, but I'm gonna let her speak to it rather than tossing it out.
Okay.
But that was an issue in this case that was addressed.
Okay. Commissioner Anderson specifically talked about maybe some reporting in the future about arrears and disconnects. Do you know what direction currently those are trending? Are you seeing more arrears, more disconnects?
I don't know which way they're trending. I think we're at probably maybe about 10,000 customers, but she may have a better idea of the trend.
Okay. And the last thing, in Ms. Tacker's opening, she mentioned that, I believe, with this increase, SWEPCO would still be roughly 20% below the national average.
Yes, sir.
Do you know what specifically that's referencing? Is that 20% below the national average on a kilowatt hour basis? Is that a total bill basis?
Yes, sir. I think she was referencing, if you look at page 20 of my settlement testimony, there's a footnote there that indicates the national average is 17.62%. That's based on the EIA data.
Oh, I see the footnote here, yeah, so it's on a kilowatt hour basis.
Yes, sir.
Do you know where we stand regionally if we approve the increase?
We have not looked at it regionally. Based on my understanding of rates across our states, I would think that this would continue to be in line.
Do you have an idea of where we would stand nationally on a total bill basis?
I believe these numbers are total bill numbers.
That number takes into account differences in usage. Obviously, some areas have, so as you mentioned,
Yeah.
I think you estimated the average residential customer uses, what, 850
Correct.
per month?
Yes.
Though the averages you present is actually higher than that, it's 1,000, right? So as far as bill impact,
Correct.
obviously that's not standard across the entire country. Some areas may use more, some use less. So when I'm talking total bill, that takes that into account. Do you know where we would stand? At the end of the day,
I don't know. We can see if we can find that data. That might also be on EIA's website. We looked at the KWH charge, but we can look at a total bill.
okay, thank you. That's all I have.
We're going to break for lunch. We're going to take about an hour for lunch. We'll come back at 12:30. And Ms. Tacker will move to your next witness at that point. Okay? So we'll be in recess. Ms. Tacker? I hope you had a good lunch.
Ms. Dagger, the chairman, has popped open his Mountain Dew, and he's ready to roll.
I've got a Celsius right here, so we're going to power through the afternoon.
It's fully loaded, so be ready.
Yes, sir. I would like to offer one item before we call our next witness. Over the break, Commissioner Tate, we did verify the answer to your question about the 3% return on Perky and how the deferred payment would be handled in the next rate case. And if you'd like for Ms. Gage to finish answering that question, we're prepared to do that. Otherwise, we can call our next witness.
Chairman, how would you prefer to handle that? Do you want to wait until all of the SWEPCO witnesses in case we have additional stuff from Ms. Gage?
Let's do that. Let's
Okay.
wait, okay? But I am worried about Mr. Chamberlain. Mr. Chamberlain, would you like to come up here and use one of these extra seats? Because those are 45-minute seats out there, okay? Okay. But you'd be welcome to if you'd like to, okay? Call your next witness.
Mr. Chairman, SWEPCO calls Lynn Ferry Nelson to the stand.
And Commissioner Anderson, I think you're going to start with her.
I think so. Hello.
Ma'am,
Yes.
do you want me to?
Oh, yes,
Yeah, go
please.
ahead,
Sorry.
go ahead.
It's the Mountain Dew. We're all jumping the gun now.
Please state your name and position for the record.
Lynn Ferry Nelson, Director of Regulatory Services for SWEPCO.
What is your business address?
428 Travis Street, Shreveport, Louisiana.
And on whose behalf are you testifying?
Southwestern Electric Power Company or SWEPCO.
Are you the same Lynn Ferry Nelson that filed direct testimony and exhibits on March the 28th, rebuttal testimony and exhibits on September 19th, and certiorari rebuttal testimony on October the 24th?
Yes,
Do you have any corrections to that testimony?
I do not.
Mr. Chairman, we tender the witness for questions from the commission.
Thank you. Ms. Anderson?
Okay, thank you. Ms. Ferry Nelson, I want to jump to a similar dialogue that I was having with Ms. Gage earlier about your customers. As I mentioned earlier, we're hearing public comments from folks that are concerned about the rising costs of utility bills at a time when there's rising costs all around us. And I know that, there are certain folks that struggle to pay utility bills on a daily basis or monthly basis. So I want to talk about those folks for a minute. I know that you all have provided some information in your testimony about a couple of programs, but before we get to that, I want to talk about what your customer profile looks like right now. Do you have numbers on current customers in arrears, disconnects? Do you have any of that information with you today?
I do.
Okay, can you kind of paint the picture for us and share some of that?
I sure can. And I've actually pulled data from, sorry, my big binder's kind of prohibiting.
It's awkward, but well, yeah.
Thank you. So I actually have data from May of this year in addition to data from November of this year, so we can kind of compare and contrast it, only because we typically see higher bills for customers during the summertime when usage is higher due to air conditioning load. So the numbers show that the balances and arrears have continued to grow, which is what we would expect. I imagine by wintertime next year, or even May of next year, that hopefully the numbers will decrease a little bit, mitigate. So as of November 14th of 2025, the number of residential accounts in arrears are 14,297 in total. So of those accounts, 30 days in arrears, 9,030 customers, 60 days in arrears, 2,333 customers, and then 90 days in arrears, 932 customers, over 90 days, 1,644 customers. The total balances in arrears, this is a little bit tricky for me. So we have a total account balance that's $4.1 million of SWEPCO Arkansas customers in arrears, but of that is a current amount of 1.5 million. So collectively, of the customers that are in arrears, The 1.5 million represents what would have been billed under their current bill. So it's not necessarily in arrears yet, but we have billed that amount. It would be outstanding, but not maybe 30, 60, or 90 days yet. So for the 30 days in arrears, we have $1.36 million, 60 days in arrears, $499,000, and 90 days in arrears, $261,000, over 90 days, $393,000. And then of that, $102,000 is a deferred amount. So that, my understanding is that is a deferred payment arrangement, but I would need to verify. We have currently 3,961 customers on deferred payment plans. So typically, following COVID, we offer a 12-month deferred payment plan where if a customer falls behind by, let's say, $1,000 in arrears, they would have to get current on their bill, I believe, and then we would divide up the $1,000 that's in arrears into 12 months of payments. So in addition to their current bill, they would be paying the 1/12 of the amount in arrears every month for the next year. Typically, we only allow a customer to default once on that payment plan, and we may sign them up for another chance to go on a deferred payment arrangement. And then that's typically it, because we want to collect from the customers. We want them to, of course, have electricity. So, to the extent we can, we're flexible, certainly within the commission's rules. During COVID, you may recall, we actually had 18 months allowed for deferred payment arrangements, but we don't typically offer that anymore. It's 12 months.
So currently it's 12.
Yes.
Okay. What other, do you offer, I'm sure you do, levelized billing and things like that that also assist customers? And can you talk about what else you offer at this point?
Sure. So right now we have, we call it the AMP. I can't even remember what this stands for, but it's a levelized billing plan, average monthly payment. And we have 15,665 Arkansas customers on an AMP, which really helps, levelize their costs of electricity, especially if they have really high peaks either in the summer or the winter, then you're paying an average price year round with, of course, a true up at the end of the year.
What was that number? Sorry, I missed it.
15,665.
So as a percentage of your total customers, you have what, 130,000?
Correct.
Okay.
So just over 10%, maybe 12, 13%. So as far as the other.
Anything else there?
Oh, I'm sorry.
No, anything else along those lines?
That's really it. I don't know if you want the differentials between the summer and winter programs, winter heating, but I can talk about the programs that we offer if you want to move into that too.
Other programs for what now? I'm sorry.
To provide customers alternatives, maybe to lowering their bill or managing their bill.
Okay. Is that leading into the programs that you've proposed here?
Yes.
Okay, we'll get to that in just
Okay.
a second. We may be there. Let me make sure. I can't read my own writing here. Okay. I also mentioned this to Ms. Gage. If the commission were inclined to ask you all to submit a report, maybe annually, we haven't, I don't know what the details look like yet, so that we can track some of that information. Would you be inclined to do that? Would you commit to do that?
Yes.
Okay.
Yes.
Because I think the numbers that you're providing here today those are exactly what we're looking for to kind of help track some of that information.
Okay.
Okay, let's move to the pay-as-you-go and the, I believe the other program is the, I just wrote it down and I can't find it now, the time of use. Will you walk through those for us? I know some of that's in your testimony, but let's go over those today. And I want to understand how your average customer can take advantage of that, and is that reach, how do you bridge the gap for some of your lower income customers?
Sure. So Pay As You Go is really a wonderful program that we introduced in Louisiana, I believe in August of this year over the summer, and have seen a pretty tremendous response thus far. I believe we're at over 2,000 customers enrolled in just a few short months. And if it's introduced here in Arkansas, I would expect we'd see the same, customer uptake for that. but it allows a customer, first off, for customers that have a deposit on file, those deposits can grow pretty significantly depending on their usage and then how many times they have made a late payment. So we can hold a deposit for 12 months if a customer makes, and I don't know the rules specifically, but it's either 1 or 2 late payments. So we continue in a year's period, we'll continue to hold that deposit. So they have to have a clean payment record before SWEPCO would return the deposit to them. So in the case of pay-as-you-go, a customer can sign up for that program. And if they're in arrears, we would apply a deposit that they have on file to that amount that's in arrears. And then as they move forward, because pay-as-you-go does not require a deposit, they would continue to pay. If the deposit does not cover the full amount that's in arrears, let's say they're in arrears by $1,000 and they had a $500 deposit on file, we would apply the $500 deposit, so they'd be $500 in arrears. Then as they made their payments under pay-as-you-go, 80% would go to their current bill and 20% would go to the amount that's owed in arrears. So if I paid $20, let's make this easy, $100, $20 would go to paying off my $500 that I still owe SWEPCO. $80 would go toward my current usage or my prepayment on the plan. And as that customer utilizes the $80 in electricity, they'll get either a text or email, depending on what communication method they signed up to receive messages. It's electronic. And the notification would be your account balance is at $10. And then they would get another notification at $0. They have 24 hours to make a payment. They can make a payment online through the regular swepco.com website, or they can go to any of our payment stations, such as Walmart, I believe. There are a number of stores in the Arkansas service territory that take payments. And then that would be credited to their account. If they had been disconnected because of lack of payment, so their account balance got to $0, the reconnection would typically occur within 30 minutes of the payment. And that's all because AMS allows us to, make that reconnection really at the touch of a button. So it would be automatic in our system, but it's constantly cycling in 30-minute cycles to get those customers back online. So if they actually paid at minute 29, they could potentially be on at the next minute.
Okay. And when will this program, and I guess the other one as well, the time of use rate schedule, would those be effective? When would those be effective?
I believe it's when the compliance tariffs are filed and approved as part, I believe,
okay.
Yeah. So maybe the first billing cycle of February or March potentially, but maybe even mid-cycle.
And what is your customer outreach? What does that outreach look like, and how do you reach those customers that probably need these programs the most?
Right. So in Louisiana, and I imagine we'll follow the same exact program here, we actually had a communications campaign to customers that were in arrears or had deposits on file with us.
So you reached out to them directly?
We did, and specifically targeted those customers in addition to regular advertising that we might undertake on social media or on our webpage. But it was a direct outreach program to those customers that may be more inclined to sign up for pay-as-you-go. And like I said, the response, it's really pleasing. It's been great, I think, for customers to really recognize they have control over their bill. They can recognize, how much they're using every day and how much that costs, and they can top off their account however many times they want to. They could pay twice in one day if that works for them.
Okay. I'm going to move on to the time of use program. Does anybody have any, Justin, do y'all have any follow-ups on this before we jump to that one?
Sure, if we want to stick just with pay-as-you-go.
It might be simpler to do it that way.
I asked Ms. Gage a question about the 12-month best bill. Can you explain how that works?
I can. So I think your question was if a customer had signed up for the program, would we look back outside the window maybe 3 months before they signed up for TOU?
So as I understand it, it's within the first year you're in the program, you can do a best bill for 12 months, right?
Correct.
So I'm trying to figure out how that overlaps unless you're doing it like exactly on day 365, you're in the program, right? So if you're 6 months into the program, is it looking back 12 months? So 6 months while you're in the program and 6 months before you're in the program?
So it could happen at any point in the program once they sign up for time of use, but it allows them to have 12 full months of time of use usage to look at the best bill. So there'll be a comparison on all of those bills each month, 12 bills, showing what they would have paid under the more typical residential tariff, and then also what they would have paid under time of use. And so the customer can see, oh, I'm saving $10 this month by being on time of use, or I spent $20 more than I would have because I was using electricity on the peak at the higher prices. And then they can ask us to essentially go back that 12-month period that they were on time of use and say, no, I want off, put me back on the residential billing program, and then they would be credited for the difference in what they would have paid under the typical residential billing program.
So it's an up to 12 months of look back. Is that a better way to put it?
Yes.
Okay. So if you decide to invoke that, if you will, the best bill 3 months in, you're only going to get 3 months of look back. You're only looking back as far as they were on time of use.
That is correct.
Yeah.
Right.
On pay as you go.
Right. And then there are other requirements too. If they do utilize the best bill provision, they can't get back on the time of use program. I believe it's 5 years is what we
time of use,
agreed.
sorry.
Yes.
I'm getting them confused now.
I know, I am too.
We were going to stay with pay as you go, and then I immediately went into time of use and stuff.
Okay, I thought, did I think that? Never mind.
I apologize.
That's okay.
You mentioned currently there are roughly 2,000 customers in Louisiana on the pay-as-you-go tariff.
Right. The last time I looked, so it could be more at this point.
So how many, as a percentage, is that within the Louisiana territory?
We serve about 240,000, 250,000, I believe, in Louisiana, but I don't recall what exactly the residential customer count is. So industrials obviously can't participate in the program. I can get back to you with that information.
Okay.
And when was that implemented in Louisiana?
I believe it was in August we started the
too long
program.
ago.
Mhm.
Okay.
It took about a year actually to program our systems to be able to manage the program under the tariff.
So you talked about for those customers that are currently in arrears, they can move over to this rate schedule, but there's a cap on how much they can be in arrears, right?
Right, they can transfer over $1,500 of the
okay.
amount that's in arrears. So they would have to, if they owed $2,000, they would have to pay the $500 upfront to be on pay-as-you-go.
So part of the advantage I see in this program is there's not a reconnect fee associated with disconnect because they don't have any money in the account, and reconnecting when they, put money towards that for future use.
That is correct.
What is the current reconnect fee under just your
I need
standard
to
rate
look.
schedule? Okay.
I believe it's $20 or $25. I don't know if I have that residential tariff even in front of me. But as part of AMS, we agreed when this commission approved the prudence of action in the AMS docket that we would slowly phase out that reconnect fee as part of our AMS program offering. So right now, I believe it's a hybrid approach for customers with and without an AMS meter since we are still deploying. And I need to, subject to check, I believe the reconnect fee is, I need to look, I'm sorry, but it is a smaller amount than what it was pre-AMS.
And you're still moving in the direction of removing the reconnect fee altogether?
That is correct.
Are you the right person to address the questions I asked earlier about opt-outs for AMS and savings so far realized from AMS?
I am, and then I left the information sitting on my chair.
Okay.
Subject
If
to
you need to
check.
have somebody run it to you, that's fine.
It's on my phone.
Yeah, that's fine.
I apologize. There was a little bit of a lunchtime scramble. So right now in Arkansas, there are 80 customers in opt-out with 128 customers pending. And then I asked for the, I'm sorry, go ahead.
What does pending status mean for?
So it could mean that they have requested that SWEPCO send them the opt-out information. And as part of that is a contract where they agree to pay a monthly fee associated with meter reading because, there's no electronic read. So we will have to go out and roll a truck to read the customer's meter. And then depending on the status of whether we've already installed an AMS meter or they have an old meter, we will have to test that meter in place or replace the AMS meter with a AMS meter. So there are fees associated with that too. So the customer signs a contract agreeing that they will pay those fees. They send it back to us with the money required, and then we would formally put them in the opt-out program. So some of these customers pending may have reached out to us, but maybe didn't necessarily return all of the paperwork or decided not to, participate in the program once they saw the costs of opting out.
And how many are under the status pending?
128 are pending and 80 have formally opted out.
Okay.
I think it's important to mention too that we rolled out a pilot program for AMS in Eureka Springs probably 5 or 6 years ago. We had aging meters there that were not providing the data that we needed. So the commission approved just a small pilot program in the interim, and not one of those customers opted out. And I think there were 1,700 meters installed. So they've been happy with the program for about 5 years now. And I don't know if you want the data points for Texas and Louisiana. In Texas, that is where we started deploying AMS meters. So they've been in place for well over a year, probably 2 to 3 years now. And only 76 customers in Texas ultimately opted out. And there's about 240,000, 250,000 customers there. And then in Louisiana, we have 167 customers with 3 pending there. So pretty small counts, all things considered.
So that,
Connor, may I approach for a moment?
sure.
I'd like to take a moment to show my witness a tariff to refresh her recollection to completely answer your question about the reconnection charge, if you would permit me to do so.
You may do so.
Thank you.
Okay, thank you. Okay. 2 and 25. Okay.
Well, if I don't fall down, thank you so much.
So for customers with an AMS meter right now, the reconnect fee is $2. For non-standard meter, it's $25.
We've bounced around a little bit. I will say that the AMS, the reason you guys are able to implement the pay-as-you-go tariff is because of the AMS meters. So I haven't deviated too much. They are related, I promise. There's a provision, I think, in the proposed tariff for pay-as-you-go that if you invoke the best bill, you cannot go back into the program. Is it for 5 years?
That's for time of use, not pay as you go.
Sorry,
Yes.
I'm
You
getting
did it
them
again.
confused again. You are correct.
That was just to keep customers from, I don't know, taking advantage of the program. Maybe that's the wrong phrasing, but we just didn't want them jumping back in and out of the programs with that best bill provision.
Well, so we can go ahead and answer that question and move on. Do you have similar provisions? Do you have residential time of use rates in your other jurisdictions?
We do, yes. We recently proposed those in Louisiana, and neither commission has required that best bill language.
Okay, so you don't have best bill in the other jurisdictions?
We do not.
Okay. The last question I had on pay-as-you-go, is there any modification needed or anything we need to do as far as the general service rules? Is your disconnect policy under this tariff consistent with the disconnect requirements under the general service rules?
So not in, as it relates to the general service rules for disconnection, no, because the customer is provided essentially 24 hours notice
Okay.
but as part of the program sign up, they agree to those terms and conditions. And I believe it was staff who mentioned that our electronic notification, because under a typical disconnection, you have to provide written notification via US mail or maybe a door hanger. That the pay-as-you-go program does not require that. So I don't know if we do need to revise those general service rules. I think they were written in the 80s and obviously not reflective of the environment that we live in today. So certainly, if that's required, SWEPCO would be willing to help with that process. I think there was just a proposal to look at those general service rules again here at this commission, isn't there, underway? Maybe a rulemaking.
Yeah, we've opened enough rule dockets at this point. I believe
We
you are
think so.
correct, but that's all I had on that tariff.
Thank you. Commissioner Anderson?
That's all I had on page.
Okay. Do you have any pay-as-you-go
I
questions?
just have one question. If the average Arkansan in your service area uses 850 kilowatts a month, and I know that houses vary, what is the square footage of that house? Do you know?
I do not know. We may be able to find that out. I'm not sure if we have that
I would be
data.
curious. I haven't seen 850 kilowatts on our bill in a long time, okay? And I admit it's not your average Arkansas house, but I think it would tell us too about the income of the people that you're serving.
I can share that given the diversity of geography within Arkansas, we serve all the way up to the northwest corner, Rogers area, that they probably have cooler summers and less usage, which may impact the
It
average.
may be newer and more efficient housing.
That could be as well. In Louisiana, our average customer usage is 12 or 1,300 kWh a month, so significantly greater given the summer cooling load. It's a lot hotter and humid, more humid.
That's the question I had.
And on that note, I had made a note earlier on the report that we talked about, I believe, adding some geographical information with the customers that are in some of those programs, the levelized billing or in the arrears category. I think adding that particular information would be helpful because there is a drastic difference between the southern portion of your territory and the northwestern portion.
Definitely socioeconomically
Right.
and usage characteristics.
For sure. So in that report, let's note that, please, as well. Okay, would you mind walking us through, and I know you've talked about this a little bit, but walk us through what the time of use program looks like from the customer standpoint. So,
Okay.
and then the outreach you're having, and are you targeting certain customers and that sort of thing?
And sorry, I know I have the tariff in this giant book, so let me
That's
find
okay.
it.
Take your time.
Take your time.
We're not in a hurry. Chairman's got his caffeine, so we're good to go for a little while.
He might have to share with me here in a minute.
More the merrier.
So we proposed a couple of time of use pilot programs. One would be a residential program where it's a whole house program. So you have 1 meter, and then there are certain billing periods of on or off peak or super off peak or super on peak, depending on the hour of the day. And each of those periods of time correlate to pricing. So during the super on-peak period, which is from 3:01 p.m. to 7 p.m. daily, where we typically see peak usage across the system, the customer would pay 14.57 cents per kilowatt hour. If they choose to use power during the off-peak period from 11:01 p.m. to 5 a.m., they would pay 4.474 cents, so about a third of the cost of the super off-peak. So if they're able to manage their load and keep their air conditioner running from 11 o'clock p.m. to 5 a.m., charge their electric car during that time, they could significantly save on the cost of electricity during that time period. But if they use it during the peak period when they get home and crank up their AC, if they have teenagers like me and come home and the AC's at 62 degrees, they're going to pay 14.5 cents, which is more than what they would pay under the typical residential regular billing tariff.
And how is that controlled from a customer standpoint? Is it also like is online? Are they like are there certain time those certain periods and the details of all of that and the peak and on peak off peak? How is that all communicated to the customer and how do they work through that in real time daily?
Right. So any customer that has an AMS meter can go online and sign up for information about their usage through the SWEPCO website. So those customers would have access to that information. It's usage by day. And then for the time of use customers, it's going to show the bar charts with, when that usage occurred.
Okay.
And then there is also a program where a customer would have 2 meters at their home. Say they had electric cars, but they didn't want to put their whole home on time of use because they want to run their air conditioner at 4 p.m. The separate meter would be for like electric car charging. Maybe their washer and dryer were connected to it. And then
Oh, I see. Okay.
only that load would be subject to the time of use pricing. So they can kind of segregate their house and for, products that may draw a lot of electricity, but they can manage it more easily. They would plug their car in at 11 or put the timer on to charge at 11 o'clock at night to 5 a.m.
Is there a reduced cost to a second meter as far as installation?
So it would be the customer's responsibility to set up for the installation, the meter base. And then, yes, there is a second charge for that meter. It's $7.73 per month for the second
How does
meter.
that compare to the first meter? Is there a reduced cost? I'm just,
So for the first meter, that's included in your base rates or your customer charge for every customer's monthly bill. And of course, that's been adjusted for the AMS meter rollout, but there is no separate meter charge for your first meter.
okay.
And what does your communication or your customer education look like for this particular program? And are you targeting certain customers? It seems to me like this would be something that would be attractive to a certain level, a certain class of your customers. But then I think I don't know how that's going to apply across the board. I guess with residentials, if you can break that down for me a little bit.
Right. I believe we have data through our customer service programs that maybe customers have an electric car in their households, and it may just be general census data, but it might be more specific to the area. Like maybe we know there's 25 customers in Shreveport that have an electric car. So I'm not really sure how the targeting of that works. I think our corporate communications group can certainly provide more details to me, and we can get that to you if you'd like to see it. But I believe they can target programs in addition to what we would put on social media or on the SWEPCO webpage as well.
Okay. Is there direct customer outreach like the pay-as-you-go program and education? Because you've got to educate folks about this. It's not something that everyone's going to understand.
Right. I don't recall the specific details, but I can certainly get back to you on that. I imagine we will be targeting those customers. We have a program called Ways to Save in the Shreveport area where our customer service reps go on a TV news station, and I don't know what the frequency is, but they share tips about ways to save on. So I think they've highlighted the time of use program and other programs. Pay as you go was highlighted on it. So I think they anticipate starting a similar program in the Arkansas service area. But I just don't have any details on that.
Okay. The time of use sounds a little more complicated to me from as far as a program that your average customer is trying to implement in their home, or how to actually make that useful in lowering their rates. The pay as you go, I can see a little more, if you're able to put money on there as you can, then that makes a little more sense to me for some customers. But I don't know about the time of use, and I don't know if there's anything else you can share with me today that will help me understand if that is actually going to be a realistic option for some folks, or if that's for certain, folks that are maybe trying to charge vehicles and do, things of that nature.
Right. I can speak from my own experience when I lived in California where rates are very high. I had an electric car at the time, and so I signed up for time of use, but I didn't have high air conditioning load. So I don't know how that translates here when I come home now in Louisiana. I mean, my air conditioners, I'm turning it on, and it might be 5 o'clock in the afternoon, which is a peak period, but I want my house to be cool and comfortable. So I'm not really sure if customer behavior will change. I think for people who have an electric car, they would certainly want to take advantage of the second metering alternative, where if they have one or two electric cars in their garage, it's probably worth paying $7 a month to get that second meter and then save with the off-peak pricing while they're charging their cars. But
Okay.
yeah.
All right. I think that's all I have right now. I'll pass the witness.
Mr. Tate?
Thank you, Chairman.
Yes.
I'm looking at paragraph 17 of the settlement agreement. Actually, I think it's I think it's Joint Exhibit A. It's in reference to the experimental curtailable service rider.
Yes, I have that.
So there's a discussion in there that SWEPCO will come back in and modify that tariff based on SPP's cone. Do you know what the current cone is for SPP?
I believe it's $87,000 per megawatt month. Jim Martin, who's following me, could probably better answer that. That's
Okay.
subject to check.
And are you familiar with the supply adequacy working group within SPP?
Slightly.
So I think they just made a recommendation for what the updated cone amount would be. Do you know what that is?
I do not.
Okay.
I believe there's
Maybe.
also a multiplier on it as well right now of 1.25, but again, I'm not
Okay.
an expert on those matters. I think we've been hearing they'll modify the cone for a couple of years now, but I don't believe that's happened, so.
Okay. Can you talk about the agreement that SWEPCO came to with U of A and Advanced Energy on that resolved the cogeneration and net metering issues?
I can say that it was a customer-specific resolution as it relates to the U of A, and my counsel can speak to that in greater detail. It's HSPI, but she's able to provide more details from the legal perspective on that.
How do we want to handle that, Chairman?
We might as well go ahead and handle it right now, don't you think?
Sure.
Let's go ahead and go in Cameron. If you have not signed an affidavit to remain in, we would ask that you step out in the hall. Why don't we take about a 10-minute break here? Be a good
Well,
bathroom break time.
Chairman, may I ask one question real quick?
Sure, sure.
Do we think we have any additional questions for Ms. Linfery Nelson at this moment, or can we start back with the next witness?
I do not have any questions.
I don't either. Thank you.
Okay, I think we may be able
So
to
you
start.
may stand down. And then we'll start back with James Martin, okay?
Thank you. Mr. Chairman, if you will afford me some latitude, I'm going to address one thing since we're back on the record publicly.
Yes, you're recognized.
Ms. Tacker, it becomes difficult for us in writing our order if we've got to point to stuff specifically that was done, either filed HSPI or done in camera here at the hearing. If there's not an objection from you or any of the other parties, could you or one of your witnesses state for the record publicly that the resolution that was just discussed is non-discriminatory, and two, you're not asking for a ruling on that issue from the commission?
Yes, Your Honor. As an officer of the court, I'm prepared to make both of those statements. It is the company's position that the customer-specific agreement with the University of Arkansas is consistent with the law and non-discriminatory to all other customers. I believe there was one other item you wanted me to include.
That the parties are not actually asking this commission to make a ruling on that issue. It was provided in the settlement agreement almost as a notice provision that your dispute had been resolved.
Yes, sir, that's correct. The University of Arkansas and the company agree that this was not specifically a term of the settlement. It is a separate customer-specific agreement. It has been resolved and thus no longer requires adjudication by the commission. And I would yield to counsel for the University of Arkansas if he has anything else to say on that matter.
Nothing else really to add to that, but just the fact that we agree with that. So.
Thank you, Mr. Bynum. Thank you, Ms. Tacker. Anything further there?
No, thank you, Chairman.
Mr. Pennington, I understand that you wish to make a motion that you have you're trying to flee the jurisdiction of the state tomorrow.
I apologize, Mr. Chairman. I do have a flight tomorrow morning at 5:30, and I wondered if the commission might accept Mr. Niergarten out of order after SWEPCO's next witness.
Okay. Is there any objection after this witness to allowing his witness to testify?
Not from the company, Your Honor. Thank you.
Staff?
Not from general staff.
Any Attorney General? Thank you. I don't hear any objection, so that will be the order. Okay? So let's proceed with, if you'll present Mr. Martin. You may proceed.
Good afternoon, Chairman
afternoon.
and Commissioners. I'm Drita Smith on behalf of SWEPCO. And at this time, SWEPCO would like to call its next witness, who happens to already be seated up here, Mr.
We're
James F.
efficient.
Martin.
That's right.
Yes, Your Honor. Would you please state your name and position for the record?
Yeah, I'm James F. Martin. I'm Director of Resource Planning Strategy for American Electric Power Service Corporation.
And what is your business address?
It's 1 Riverside Plaza in Columbus, Ohio, 43215.
And on whose behalf are you testifying today?
SWEPCO.
And are you the same James Martin who filed direct testimony on March 28th, 2025, rebuttal testimony on September 19th, 2025, and sir rebuttal testimony on October 24th, 2025?
I am.
Do you have any corrections or revisions to that testimony?
I do not.
And at this time, I'd like to tender the witness for the commission's questions.
Thank you. Who wishes to go first? Mr. Tate? Ms. Anderson? Mr. Tate?
Sure. I think I just have one issue I want to discuss with you, Mr. Martin. In this settlement agreement, SWEPCO, well, I'm looking at paragraph 34 of Joint Exhibit A. It says, in recognition of the City of Fayetteville's request for SWEPCO to commit to a good faith effort to procure a meaningful clean energy solution in Northwest Arkansas, you guys are committing to do an all-source RFP, open to proposals for technologies available at the time of the request. This is looking for a meaningful clean energy solution in Northwest Arkansas. Can you tell me exactly what you're committing to beyond just an all-source RFP? Or is that the extent of the commitment?
Yeah, I not a lawyer, but that's what I understand the commitment to be. We will seek any and all types of resources in our next RFP.
Have you used or has SWEPCO utilized all-source RFPs in the past?
We have.
Have you Are all of your RFPs all source?
We issue from time to time RFPs only for short-term capacity agreements. But when we are looking for long-term resources, yes, of late and in the future, we expect all of them to be all source RFPs when we're looking for longer-term resources.
Does SWEPCO ever do jurisdiction-specific RFPs?
We have not.
Is that something the the company is open to in the future?
I don't think I'd want to speak for the company on that. Might be a better question for Witness Gage.
Okay.
We've not done that in the past. We do resource planning for all of the company's customers in generally in the same RFP. That's been our practice to date.
So as I understand that, the way that paragraph is written, Fayetteville has requested SWEPCO to commit a good faith effort to procure a meaningful clean energy solution in Northwest Arkansas. SWEPCO has not agreed to that. SWEPCO has agreed to just doing an all source RFP where those types of solutions could bid into the proposal or respond to the request.
Yeah, that's my understanding is just the words on the page. You know, clean energy in Northwest Arkansas will be eligible to bid into that RFP when it happens.
But it's not a commitment that ultimately will end up being selected out of any.
That's right.
That's all I have. Thank you, Chairman.
Thank you. Commissioner Anderson?
No questions, thank you.
No questions. You may stand down.
Thank you.
Mr. Pennington, call your witness.
Your Honor, may I approach first for a moment?
You may.
We would ask that the commission excuse Mr. Martin from the remainder of the hearing so he can travel back to his office and continue working.
Is there a reason that we need to have him here? While we've got a little break in the action, I anticipate that we will go till 5 o'clock today. I have a meeting in Benton at 6. If we are not finished, we will reconvene on Friday at 9 a.m. It's good. We've got 3 hours. Okay. So do you have a,
You're putting this on me, huh?
no, well, we have 3 hours. Do we need to, can we release him? Or
I think so. I think any follow-up questions and related to Mr. Martin's testimony can probably be addressed by Mrs. Gage.
He may be released to Ohio, and we will notify the jurisdiction that he is now in their responsibility.
Thank you for your consideration, sir.
That's right. Thanks for coming to Arkansas. Mr. Pennington?
Thank you, Mr. Chairman.
Thank you.
Please state your name and position for the record.
My name is Peter Nierengarten, and I'm the Environmental Director for the City of Fayetteville.
What is your business address?
113 West Mountain Street, Fayetteville, Arkansas, 72701.
And on whose behalf are you testifying?
On behalf of the City of Fayetteville.
Are you the same Peter Nierengarten who filed testimony in this case, direct testimony on August 22nd, rebuttal testimony on October 16th, and settlement testimony on November 10th?
Yes, I am.
Do you have any corrections or edits to those filings?
No, I do not.
And as Ms. Tacker stated in her oral motion at the beginning of this hearing, the statement that Fayetteville takes no position is with respect to investments in Flint Creek and not the Welsh power plant. Is that correct?
That is correct.
I tender the witness.
Thank you. Ms. Anderson, do you have questions?
Not right now, Chairman, thank you.
Mr. Tate? I want to know what heritage your last name is. What is your descendancy?
It is German, sir, but it is from the German-speaking portion of France.
Neat.
Yes.
Neat. Okay.
In that Alsace-Lorraine region that was fought over between World War I and World War II.
I've been there,
Yeah,
yeah.
Strasbourg is the name of the town.
Thank you for, I'm always curious about heritage.
Yes.
Okay? Thank you.
Good afternoon.
Good afternoon.
As I understand it, this is a non-unanimous settlement agreement. However, the parties that didn't sign on are not opposing the agreement. Is that your understanding?
Yes, sir, that's my understanding.
Fayetteville is one of the parties that signed on to the agreement, though, correct?
That is correct.
So I'm sure you're aware, as we are, the number of folks that have filed comments in this docket, a number of which are Fayetteville residents, I believe.
Yes, sir, that's my understanding. 157 comments on the public record. I don't know how many of those are Fayetteville residents, but in Fayetteville, approximately 2/3 of our residents are SWEPCO customers.
So those comments raised a number of issues, including affordability of the increase, as well as a desire for a clean energy solution in the Northwest Arkansas area. As a party that agreed to this settlement agreement, what's the message you're going to take back to the folks of Fayetteville about why this is in their interest?
I think the primary message is twofold. One is that we're seeing a meaningful reduction in the amount of the rate increase that's proposed as part of the settlement as compared to the originally proposed rate increase back in March. It's approximately been cut in half. And secondly, our primary objection with respect to the rate increase was the $31 million worth of spending on the improvements at the Flint Creek coal plant. And while those improvements have not been disallowed, which was our request, we are seeing as part of the settlement meaningful study at what early retirement of Flint Creek could look like through the resource retirement study with 2 early retirement years, 2030 and 2035, I believe it is, as part of that study that will be conducted by the Southwest Power Pool. So we feel good about that as a compromise, and we'll bring that back as a message to our residents and businesses.
So I think Mr. Pennington referenced a climate action goal that Fayetteville has in his opening. Can you tell me a little bit about that?
Sure, I can. We have, in 2024, our city council unanimously adopted a new climate action plan for the city. In that plan, there's 2 goals related to clean energy. One is a goal of getting city government operations electricity consumption to 100% clean energy by the year 2030. And the second goal is a goal of getting the entirety of the electricity consumption in the city of Fayetteville to 100% clean energy by the year 2050.
Okay. I appreciate that's the goal of Fayetteville, but you would acknowledge that the rest of SWEPCO's territory within this jurisdiction may not share the same goals.
Yes, sir.
And that Flint Creek doesn't just supply power to the folks in Fayetteville.
Yes, sir. We definitely understand that.
Have you explored any opportunities with SWEPCO if ultimately it's determined that the best resource long-term in that area is not one that would meet your goals for clean energy? Have you explored other opportunities with SWEPCO about how you might be able to supply Fayetteville with clean energy through sleeve PPAs or some other kind of novel tariff design?
Yes, sir, absolutely we have. We're currently working on a 3.7 megawatt solar PPA in the SWEPCO service territory near Nashville, Arkansas, and that will offset much of the city government electricity consumption and take us from, I think we're at about 80% clean energy currently. It'll get us to about 92 or 93% clean energy city government operations. That project should be online by the end of this year. And we, up until this point, we haven't had extensive dialogue on meaningful movement for the larger city and clean energy opportunities. But we are optimistic that given the terms of the settlement that will open up that dialogue and that we can begin to work with them towards that end.
I think that's all I have, Chairman. Thank you.
Thank you. I have nothing further. You may stand down.
Thank you.
And Mr. Pennington, I think you wish to make a motion to be excused.
If that's okay, Mr. Chairman, I was hoping to avoid dodging deer on our way back to Fayetteville this evening.
Okay. I don't think there's any objection. You may be excused. Ms. Hacker, or please call your next witness.
Thank you, Mr. Chairman. The company calls SWEPCO witness Jeff Ellis. Mr. Ellis, please state your name and position for the record.
Jeffrey L. Ellis. I'm the Transmission Planning Manager for the SPP region for SWEPCO.
What is your business address?
212 East 6th Street, Tulsa, Oklahoma, 74119.
On whose behalf are you testifying?
SWEPCO.
Are you the same Jeffrey L. Ellis that filed direct testimony on March the 28th, rebuttal testimony on September the 19th, and certiorari rebuttal testimony on October the 24th?
Yes, ma'am.
Do you have any corrections or edits to those filings?
No, ma'am.
We tender the witness for questions from the commission. Thank you.
Ms. Hacker. Mr. Tate, any questions?
I do. Thank you, Chairman.
You're welcome.
The SPP resource retirement study that SWEPCO's agreed to request for Flint Creek, can you provide some more detail on what that looks like?
So in my certiorari rebuttal testimony, I get into it a little bit. Let me see if I can find it. But basically, we'll create a case or a model that has Flint Creek in it to start with, right? We would look at that model, and then we would compare it to a model that has Flint Creek off, right? So not online, we're not able to come back online to support the area. We would take those two cases or those two models, we would run load flow analysis or the NERC reliability analysis that's also in Business Practice 7800 that shows basically you would take all the contingencies in the area to show the reliability of that area. Specifically, it would use those contingencies, and as part of the analysis, you would compare basically case A with Flint Creek on to case B with Flint Creek off.
And so once you make that comparison, what is the ultimate, what does it point you to as far as early retirement for Flint Creek, or what the replacement would be, whether it's in 2030, 2035, or I think the current retirement date's 2038?
2038, that's correct, yes.
And is it taking all of those dates into account, or?
No, sir, so I'll address that question first. So 2035 is the furthest out case that we have for the ITP, the Integrated Transmission Plan for SPP. So we're not doing 2038 yet. It's also in my testimony where in 2029 is when the 2038 case would be created so that we could look at that specific case. Again, 2035 was picked because that's the furthest out case that we can use with SPP. And then 2030 was just agreed upon as part of the settlement as to also look at that date. What was your other question associated with it? You had more on that, I think.
So you're doing a comparison between Flint Creek being on, if you will, and Flint Creek being off.
Yeah.
That's giving you an idea of the reliability that unit provides in the area and what happens if it is not there.
Correct, sir.
But does it point you to solutions if Flint Creek is not there, as far as generation type or what would be needed as a replacement?
So this particular study, attachment AB, does not include replacement of generation resources. That's in attachment V, as in Victor, that would look at different resources for Flint Creek. This particular one would just focus on the transmission facilities to help support the Fayetteville area. So they would go through and look at different things. They would look at operating guides as part of the mitigation. They would look at maybe reactive devices that they could use, being maybe StatComs, capacitors, other things in the area that could help support the voltage in the area, as well as maybe dispatch changes of units in the area. You could bring up Madison, for example, or other units that could be close to there. And then in usually the final thing they look at Commissioner Tate, is a lot of times mitigation around transmission, right? Looking at maybe a new greenfield line and or alternatives, right? They said reconductor or, DLR, dynamic line ratings, different things like that associated with different types of upgrades on the transmission system to help support the issues there.
Right, so the study you're talking about is really just looking at whether the system can operate within the guidelines without that unit present.
Yes, sir.
Okay, so okay, I think that answers my question. In paragraph 32 of the joint exhibit, the agreement is that the settling parties will be given an opportunity to engage on the preparation of the scope of the requested study with the company. Flint Creek is a shared resource, is that correct?
Correct.
Who are the co-owners?
AECC and SWEPCO.
So the co-ops are not parties to this docket. So what is their ability to participate in the setting of that scope?
They can participate in the study that's already been agreed upon.
Okay. Once the study is published, if it points to an earlier retirement date, what are the next steps?
So the study's not necessarily going to point to an early retirement date. It would just mitigate if Flint Creek were offline. It's still the company's thought process to still retire that in 2038. We'll look at the reliability from a transmission grid associated with this study, but there's no intention of retiring Flint Creek early.
That's all I have. Thank you.
Thank you.
Ms. Anderson? You may have stated this, and I was not listening well. The co-ops own what percentage of Flint Creek?
I don't know off the top of my head the exact percentage, but we
I
can
think
find
it's
out.
50-50.
I believe that's right.
I see a bunch of people nodding their
Okay, yeah,
heads
I
back
believe
there.
that's right. I'm just not
Okay.
certain. Yeah.
50-50.
Okay, yeah.
I just wanted to get that in the record, okay?
Sure. Yeah, it works for me.
You may stand down.
Thank you, sir.
Thank you.
Thank you.
I appreciate the jury pool back there, okay? Thank you, thank you. Thank you, thank you.
Mr. Chair, can we excuse Mr. Ellis back to Oklahoma, please?
Does Oklahoma want him back?
I'm not sure, but we'd like to give him the opportunity.
I think we could excuse him.
Thank you,
okay?
sir.
Okay. Spend some money on the way on I-40. Arkansas is a poor state, okay? Call your next witness.
Thank you, Mr. Chairman. At this
Thank you,
time,
Ms.
SWEPCO would like to call Jason Stiegel. Please state your name and position for the record, please.
My name is Jason M. Stiegel. I am employed by the American Electric Power Service Corporation as the Director of Regulatory Services for fuel and purchase power related filings.
And what's your business address?
1 Riverside Plaza, Columbus, Ohio, 43215.
And would you please tell us on whose behalf you're testifying today?
SWEPCO.
And are you the same Jason Stiegel who filed rebuttal testimony with an exhibit on September 19th and Sir rebuttal testimony with exhibits on October 24th?
Yes, I am.
Do you have any changes or corrections to those?
I do not.
Okay, at this time I tender the witness for commission questions.
Ms. Anderson?
No questions, thank you.
Mr. Tate?
Thank you, Chairman. Paragraph 33 of the settlement agreement, SWEPCO is committing to a confidential economic analysis regarding the self-commit of Flint Creek for the applicable historical year. Are you familiar with that commitment by SWEPCO?
Yes.
Can you describe a little bit what self-commit means? and how that process works?
So self-commitment or a commitment status designation of self in the SPP energy markets means it is the owner or operator of the plant, in this case SWEPCO, making the decision to turn Flint Creek on or keep it on for the next operating day.
And there's a number of reasons why you might do that, right? Basically, what you're saying is that it wouldn't otherwise be picked up in the market. Someone might call that an uneconomic dispatch, but there are reasons why the utility might want to self-commit.
Yes, and in the shortest possible explanation, the company manages its generation resources over more than the next operating day, which is SPP's parameter. So for a coal unit that doesn't turn on and off instantly, you may keep it on Friday so that it's available Monday morning, knowing that you couldn't take it off Friday night and then have it back up online on Monday morning.
If the RTO makes that request of the utility, is it still a self-commit, or is that addressed through like the make whole provision separately?
So in situations where SPP is looking out into the next several days and seeing a reliability need for Flint Creek, they do have a reliability unit commitment process to inform us to bring the unit online. Yeah.
If based on if that analysis determines, well, if uneconomically incurred costs are identified through that analysis, how will the company proceed?
So when I think of economic analysis, I think look at the cost of the company's decision and the cost of the next best option. So what the company's economic analysis will do is say for the hours that the unit was committed, was self-commit, here was the economic result. Had the company opted not to do that, what would have been the alternative reality of taking the unit offline? So I think any analysis like this would include some sort of explanation to say, well, we kept the unit on and we incurred a loss over the weekend, but it was small. Had we taken it offline and had to restart it, it wouldn't have been available until Wednesday, and the company made this amount of margins on Monday and Tuesday, making this a positive decision on customers' behalf.
Right, so the results of the economic analysis are not necessarily determinative of whether the decision to self-commit was prudent or not. Does that make sense?
I would
the
say
analysis could point to the cost being uneconomically incurred, but that doesn't mean that you made the wrong decision keeping the resource or self-committing the resource.
Yes, I would say that the analysis is sort of an indication of where you need to look further. So yeah, we would provide additional information to put decisions in context.
Flint Creek's not the only resource you guys self-commit. Is that right?
Correct. Yes.
What jurisdictions does SWEPCO operate in?
It operates in a federal jurisdiction, the Texas retail jurisdiction, the Louisiana retail jurisdiction, and the Arkansas retail jurisdiction.
Have any of those jurisdictions determined that SWEPCO self-commits were imprudent?
No, we did recently enter into a settlement agreement in our most recent Texas fuel reconciliation to provide a similar analysis to what we agreed to here. Again, providing additional information for interveners and commission in future cases to look at the company's decisions to self-commit. And we think our decisions are prudent, but this would put numbers, explanations to those decisions.
Did Louisiana ever disallow costs related to self-commits for Dole Hills?
The Louisiana jurisdiction, we did have a disallowance of Dolet Hills costs that arose out of a settlement agreement. So and Dolet Hills was a much more complicated plant that we're talking about here with Flint Creek because SWEPCO owned the mining resources as well. So that, so the facts are a bit different there.
But did that disallowance stem from self-commit of that facility?
The disallowance stemmed from the settlement agreement. I don't know that we ever assigned
So
the
you're not
disallowance.
assigning the disallowance as to anything specific. It was just an agreed to disallowance.
Yes.
I think that's all I have. Thank you, Chairman. Thank you.
Thank you for being here. You may stand down. I assume you want him to flee the state. If he leaves, the IQ of Arkansas will increase and Ohio will decrease. I'm
Yes,
kidding,
sir.
of course.
How'd you guess what I was going to ask?
I just could read it, okay?
Yes, sir.
He may be excused,
Yes, sir.
okay?
Um,
Safe travels, safe travels.
Would now be an appropriate time to reoffer Ms. Gage for the follow-up questions, or would the commission prefer to do that later?
Can we have 5 minutes, Chair? I don't want to have to recall her a second time, so just to collect things.
Let's
and
do
make sure.
this. We may take her, but let's go ahead and take the Attorney General's witness, because he may, and that'll give us time to think about Ms. Gage.
Sure.
Is that okay?
For what it's worth, sir, I've told her she has to stay the whole time, so I won't be asking that she gets to leave.
Okay.
So she's here.
So we can be the good guys.
Absolutely.
Okay, thank you. Ms. Chandler, I see you've called your witness.
I have.
Okay.
At this time, I call Greg Meyer. Will you please state your name?
Greg Meyer,
And what is your business address and whom are you with?
16690 Swingley Ridge Road, Chesterfield, Missouri, 63017, and I'm a senior principal with Brubaker and Associates, Inc.,
And on whose behalf did you provide testimony in this case?
the Attorney General.
And was that testimony, did you provide direct testimony on August 22nd of 2025, sir rebuttal on October 17th, 2025, and settlement testimony on November 10th of 2025?
I did.
And do you have any corrections or modifications to that testimony?
I do not.
I would tender the witness.
Thank you. Ms. Anderson? Okay. Mr. Tate, any questions for Mr. Meyer? I know Is he from out of state?
Good afternoon, Mr. Meyer.
Afternoon.
I think it was in your settlement testimony that you mentioned withdrawal of the proposed system improvement plan rider was beneficial to customers.
Yes.
Outside of that rider, is the AG opposed to targeted resiliency investments? And what would be the best way to approach that going forward?
You mean investments for resiliency?
Yes.
Well, the SIP is a rider, okay? And personally, I'm opposed to riders and trackers because I'm sure you've heard this, they've engaged in single issue rate making. So if you didn't have the SIP, I think you would just have to resort to rate cases to recover those expenses. And then at that point, you can look at the prudency of those investments and include them in rate base at that time.
Right. So to be clear, you're not opposed to the purpose of the rider. It's the fact that it's a rider. It's how it's being recovered that you're opposed to. It's
Well,
so
I'm
if
sorry.
again, the specifics, you'd have to get into the specifics of the individual investment, but resiliency investment generally you're not opposed to. It's just if the company's going to do it, it should do that through base rates, not through a separate rider.
That's correct.
Okay. Is the AG's office satisfied with the proposed revenue distribution by rate class that's been agreed to in the settlement agreement?
I did not address that issue, but I would refer to Ms. Chandler to determine that. My focus and what I was hired for was revenue requirement.
I think that's all I have, Chairman. Okay.
Any questions?
I have one question, thank you.
Okay.
Mr. Meyer, in your opinion, The efforts by SWEPCO to initiate any customer protection programs in this settlement, do you find those satisfactory?
I specifically did not look at the customer protection programs, but generally, to the extent that they encourage customers or allow customers to stay on the system and receive service, that would be something of goal of the AG, I would assume, and what should be promoted. Now, there's a cost to that, and we have to look at that cost, but the idea of trying to keep customers online during these periods of high rate increases, I think should be encouraged.
Okay. Are there any other recommendations you would have for SWEPCO in this case, as far as, or even if you don't want to be that specific, are there other programs and efforts that you've seen in other states that utilities have put into place in rate cases with significant increases that you think are significant customer protections, and would you recommend those? There's along, like in similar cases, I guess. Sorry, I twisted that up
That's
a little
okay.
bit. But.
No, I wouldn't. I'm not here to change the settlement agreement. I think it's a reasonable agreement that was negotiated amongst all parties. If you encounter large rate increases or what you determine to be large increases, there are mechanisms with gradualism or phase-in rate increases that you can look at. Those were really prevalent during the what I'll call the nuclear age of the 1980s, when utilities were bringing on nuclear power plants and their rate bases were doubling. And so in those to alleviate rate shock, phase-ins were proposed and implemented that allowed for gradual rate increases, over several years. That's a tool you can look at in today's environment as well.
And I know you testify on these matters, and you've testified in many states on issues like this. So are there any other trends that you are seeing in other states as far as customer protections and programs that utilities are using?
No, I think that from my understanding of the ones that SWEPCO has offered, those are common across, many jurisdictions. I can't recall at this time something that jumped out at me that said, hey, there's the model.
Okay. That's all I have, Chairman.
Mr. Tate, anything further?
You mentioned gradualism. You're not advocating for that in this case, though, right?
No, this settlement is fine. That was an example. If you felt in a future case that you had an extraordinary rate increase outstanding, that's one way you could address it.
Is there a general threshold or a point at which you would suggest a rate increase is exorbitant enough to necessitate gradualism?
Well, I think you have to look at it on an individual rate case perspective. What may be large in Arkansas is minor in California. So I think it's you have to look at the situations, you have to look at the jurisdictions, you have to look at the rates to make that determination.
Thank you.
Nothing further.
And just to clarify, you are the one witness for the consumer advocate here. So my hope was that we could just pull from your expertise just generally. I wasn't meaning to indicate that you were trying to change anything in the settlement. The questions were more for you as an expert who's testified on this matter across many states according to your testament. So that's where I was going with that. So if you have anything else to add in light of that, please do so.
Well, let me just emphasize, even across the United States, I concentrate on revenue requirements. So I do not get in. We have other people in our company that gets into rate design and customer programs, but I don't specifically do that. My knowledge is from what I've gleaned over the years, many years of rate case activity. So.
Okay, no further questions.
Thank you. Ms. Chandler, do you have any objection to us releasing this witness? You may stand down and you're released.
Thank you.
I kind of got us out of order, but I'm trying to be considerate of people that are going to be leaving the state. Mr. Bynum, do you want to call Mr. Blank? Does he live in Arkansas?
No, he does not. He lives in New Mexico, so.
Well, he can, he might as well stay in Arkansas. It's a better state, okay?
That's what I've tried to talk to him about, but I think he has a wife that may object to that.
I understand. Appreciate you being here, Mr. Blank.
Although his wife
Thank
does.
you.
Thank
Mr.
you.
Chairman.
Although his wife does work for SPP now, so.
Ah.
Yes, so we're trying to get him to move to Arkansas. Okay, thank you.
Yes, sir.
Could you, for the record, could you state your name, occupation, and business address, please, for the record?
My name is Larry Blank. I'm an economist. I'm also a consultant, principal with Tahoe Economics, LLC, a consulting firm specializing in public utility policy and regulation. My business address is 6061 Montgomery Road, Midlothian, Texas, 76065.
Thank you. And did you file direct testimony on August 22nd, rebuttal testimony on October 17th, and settlement testimony on November 10th in this case?
Yes, sir, I did prepare those testimonies.
Okay. And did you want to make any changes to those
No,
testimonies?
No,
Okay.
sir.
Okay. I tender the witness for
Thank you,
questions
Mr.
by the
Bynum.
commission.
No questions, thank you.
Mr. Tate?
Good afternoon.
Good afternoon, Commissioner Tate.
Were you in the room when I questioned Ms. Gage earlier about riders and its effect, or whether it should have an effect on the ROE?
Yes, I was.
From your perspective, what is the benefit to a utility of having riders?
Well, one benefit I think she mentioned as well is cash flow. Cash flow from the perspective of the utility can be stabilized through the use of riders or other alternative recovery mechanisms. Another benefit is to stabilize, well, similar concept, stabilize revenue flow to the utility company in terms of regulatory lag. Many people focus on regulatory lag, that period being between the time perhaps investments are made and the time at which under traditional regulation they would seek recovery within a general rate case. But we have to remember there's also regulatory lag after approval of new investments that are placed into rate base, because those remain at that level in rate base until the next time we have a general rate case. So I refer to these as ex ante regulatory lag, which is that period while the utility waits under traditional regulation to gain approval of that rate base addition. But there's also ex post regulatory lag, in which the utility company under traditional regulation gets to enjoy that fixed amount in rate base and built into the revenue requirement which set the rates in that rate case until such time as there is another rate case.
Are you familiar with some of the riders SWEPCO has in this jurisdiction?
I'm not going to try to recall all of them. I mean, I have looked at some, but I wouldn't be able to enumerate those.
Are you familiar with the formula rate review rider here in Arkansas?
Yes, I am.
What about Act 373's rider, the Generating Jobs Act rider that was provided in recent legislation?
I have looked at that. I'm not going to claim to be an expert on it by any means.
What is your opinion on how those riders affect risk for a company like SWEPCO?
I believe those types of mechanisms do tend to reduce short-term risk, and certainly may have the potential to reduce long-term risk. I believe in terms of short-term risk to the shareholders, certainly there would be a reduction.
So how should a commission like ours take that into account when determining the appropriate ROE for a company?
I think it should be taken into consideration in the context of this particular hearing focused on this settlement. I would suggest that the parties who have reached that agreement pertaining to ROE have taken that into account. The risk profile of SWEPCO, including the various riders that they have approval for.
Only those riders they currently have approval for? Or that at least would be approved as part of us approving the settlement agreement?
Existing riders and any riders that would be approved as part of the agreement.
I think you also testified to the retirement issue, or the issue of retirement of Perky. Is that correct?
Yes, I did. In terms of cost recovery, yes.
So I understand what was agreed to here. I think you initially had advocated for the long-term debt rate as far as a return on the investment for Perky. Is that correct?
I believe, we could go back and look, I believe no greater than the cost of long-term debt as a carrying charge, yes.
So I have a bad habit of summarizing what I think is a party's position, so I'll allow them to correct me when Ms. Gage gets back in your seat. But as I understood it, SWEPCO's position is that the default should be that when you have a prudent retirement, or if a retirement is deemed prudent, they should get both a return of and a return on that investment. Do you share that opinion, that that should be the default of a return on a prudent retirement?
I think it depends on the circumstances as to what is causing the need for the early retirement. And then also, of course, which I believe I testified to in my direct testimony, if there is going to be a return on that regulatory asset, it should be adjusted for risk. Because as I've testified, the risk associated with that retired asset, in my opinion, is lower than the risk of an operating asset, both in terms of operating risk and in terms of regulatory risk. If this commission approves a recovery mechanism for that retired asset.
Yeah, so it's not that that the retirement of some facilities is more risky or less than others. It's just the fact that it's retired, it's less risky. Period, I guess.
It has lower operating risk.
Sure.
Because if it is retired, there's a variety of issues that can come up in the operation of plant. Regulatory risk should also be taken into consideration, but with approval of this settlement and an order that allows SWEPCO recovery of the remaining book value of Perky, that also greatly reduces regulatory risk going forward in terms of recovery of investor money.
Have you ever testified on the retirement of a facility you determined to be prudent, but still advocated for no return on that retirement?
Well, first of all, let me clarify. I don't recall making a prudency determination in this case or in prior cases. However, I have testified on and given recommendations regarding recovery of plant that was early retired. I don't recall. I've had a long career. I'm sorry. I'm sorry, Commissioner. At least the recent recommendations I have given have included some carry on the regulatory asset. So that would be some return on. However, appropriately risk adjusted.
So I missed the first part of that. I apologize. Did you say that you have always advocated for some return on?
Well, in my recent memory on cases I have worked on in, say, the last 10 years, I have made recommendations that have included a return on or a carrying charge on that regulatory asset. But again, it depends on the circumstances, and I may be forgetting something in my distant past where, you know, carry may not have been appropriate because of the particular circumstances.
What about acceleration of the depreciation period? What do you normally suggest in regards to that?
What I have suggested, not here, I know of at least one case in which I recommended that the amortization period be consistent with the remaining expected life of that asset at the time at which it was decided to early retire. So if the expected depreciation life was another 12 years, I have made recommendations in the past for amortization over that same 12 years so that the amortization expense approximately equals what the depreciation expense would have been.
And you would agree if you're going to accelerate that if a return on is provided, that should be reflected in the return on as well.
I would agree with that statement, yes.
I think that's all I have, Chairman. Thank you. Thank you, Mr. Blank.
Yes, Commissioner.
I have no questions, Mr. Blank. We appreciate your coming here, and you may stand down and you're free to go.
Thank you, Mr. Chairman.
Thank you. He may be released.
Thank you very much.
Yes, sir. Spend money before you leave.
Yes, sir. I'll be here until tomorrow morning.
Oh, good, good, good. There's some fine restaurants in Little Rock.
Thank you.
Mr. Tinsley, are you leaving? You have not been released.
He was trying to go quietly.
I know he was, but Tinsley cannot go anywhere quietly. You may be released as well. Just don't get arrested again. I'm kidding, of course. Okay. Take care. Take care. Do we need a break or we're fine? Mr. Schrader, you want to call your witness?
Thank you, Mr. Chairman. Waylick calls to the stand Mark Garrett.
Thank you.
Mr. Garrett, good afternoon. Please state your full name and occupation for the record.
My name is Mark E. Garrett, Garrett, and I'm a consultant in the utility regulation area.
And can you please provide your business address to the commission?
My address is 4028 Oakdale Farm Circle, Edmond, Oklahoma, 73013.
And on whose behalf are you filing, did you file testimony?
WALAC, Western Arkansas Large Industrial Consumers.
Okay. And did you file direct testimony on exhibits on August 22nd, 2025?
Yes.
and sir rebuttal testimony and exhibits on October 17th, 2025,
Yes,
and stipulation testimony on November 10th, 2025.
I did.
And if I asked you the questions that are in your testimony today, would your answers be the same?
They would.
And I tender the witness for examination.
Thank you, Mr. Schrader.
Thank you.
Mr. Tate, any questions?
Just one, I think.
It's a big one. I'm just kidding.
But it may only be 2:45, but I feel like we've been here for a while, so I apologize if I start getting testimony and various witnesses confused, but I believe it was you, Mr. Garrett, that testified about concern about wagon wheel and when it would go into operation. Is that correct?
That's correct.
Can you tell me what the basis was about for your concern that it wouldn't be in operation before the end of the period?
Well, I think when the application was originally filed, there was some question about what the completion date would be. And so as the case progressed, though, the company was able to provide a more surety that the project would be done by the end of the projected year. And so, in other words, should be allowed in rates. So some of the questions that they had initially were resolved during the course of the case.
So those questions have been resolved to your satisfaction?
Yes.
Can you provide any detail on what helped answer those questions? Why you feel more sure now than you were before?
Well, I raised the issues in my direct testimony, and the company provided rebuttal testimony about the progress of the project and the completion date, the certainty of the completion date in their rebuttal testimony. And so we were satisfied. There weren't any other parties that were concerned. Staff was not concerned, and so we felt that was sufficient to include the project in rates.
So the information they provided in the rebuttal testimony is what satisfied your concern?
Correct.
There was nothing else?
No.
Okay. That's all I had. Thank you, Chairman.
No further questions, and you may be released.
All right. Thank you.
Thank you.
Your Honor. If Mr. Garrett promises to spend money while he leaves and goes back to Oklahoma, may he be released?
He may be released.
Thank you.
Yeah, but we will follow up on that promise.
I will produce receipts.
Thank you. Thank you. We've got utility bills to pay. We need, Ms. Kelleher.
Thank you, Mr. Chairman. Staff calls Middleton Ray.
Hello.
Mr. Ray, can you please state your name and position?
I'm Middleton Ray, and I'm a rate case analyst.
And for whom do you work?
The Arkansas Public Service Commission in the gas and water section.
Okay. And what is your business address?
Oh, it's a test.
If I said it was 1000 Center Street, Little Rock, Arkansas, 72203, would that be correct?
That would be correct.
Okay. And were you the same Middleton Ray that filed direct testimony and redacted in HSPI direct exhibits on August 22nd, 2025, sir rebuttal testimony, HSPI and redacted sir rebuttal exhibits on October 17th, 2025, amended sir rebuttal testimony redacted in HSPI, amended sir rebuttal exhibits on November 7th, and an errata HSPI amended sir rebuttal exhibits filed on November 7th.
Yes, I am.
Okay. Do you have any corrections or additions to that testimony?
No, I do not.
Tender the witness.
Thank you. Ms. Anderson?
No questions. Thank you.
Mr. Tate?
I don't think I have any questions from Mr. Ray.
Mr. Ray, you may stand down.
Thank you.
You cannot leave the state of Arkansas. There you go. But start working on the fact that you work at 1000 Center Street, Little Rock, Arkansas.
I think that's been his work address for quite some time.
That's right. He knows how to get here, he just doesn't know the address. That's right. That's right. Ms. Kelleher.
Thank you, Mr. Chairman. General Staff calls Victoria Temple. Could you please state your name, address, and name, position, and business address?
My name is Victoria Temple, and I'm the audit manager at the Arkansas Public Service Commission, and our address is 1000 Center Street, Little Rock, Arkansas.
All right. Are you the same witness that filed testimony, redacted direct testimony and redacted direct exhibits on August 22nd of 2025, errata HSPI direct testimony and HSPI direct exhibits on August 28th, 2025, and surrebuttal testimony and surrebuttal exhibits on October 17th of 2025?
Yes, I am.
Do you have any corrections or changes to your testimony?
I do not. Can I say it louder? I do not.
Thank you. We tender the witness.
Thank you.
No questions, thank you.
Mr. Tate.
No questions, Mr. Chairman.
You may stand down. You too must stay in Arkansas. Ms. Kelleher, call your next witness.
Thank you, Mr. Chairman. General Staff calls Mark Burdette. Could you please state your name, position, and business address for the record?
Mark Burdette, Senior Rate Case Analyst 2. I work in the Cost Allocation and Rate Design Group, Arkansas Public Service Commission, 1000 Center Street, Little Rock, Arkansas. Even closer, okay.
There you go.
Are you the same Mark Burdette that filed direct testimony, redacted and errata HSPI direct exhibits on August 22nd, 2025, surrebuttal testimony and redacted and HSPI surrebuttal exhibits on October 17th, 2025?
Yes,
Do you have any corrections or additions to your testimony?
I do not.
We tender the witness.
Thank you.
No questions, thank you.
Mr. Tate.
Mr. Burdette, you were in the room while we asked questions of the company about the various new tariffs they're proposing.
I was.
Do you have anything you want to add on that, or any clarifications that you think might benefit us on how they explain those?
No, we had concerns about the declining block rate, but, and that's in the goal of energy efficiency overall. Our proposal was to eliminate block rate within 5 years, and the company agreed. In fact, it might be gone even before 5 years, so we were good with that. I proposed the 1-year best bill, and the company agreed to that. The other, as written, we are good with.
Are you okay with the 5-year stay out on the best bill?
This is all new. And I see it as kind of some precedent and policy. I don't have a good answer for that. When you said that, my initial impression was that seems like a long time, but I also know the company's fear of somebody trying to game the system, where they get on it and they use it and then they get off. I mean, I believe that's probably a real fear. So I don't know. I don't know about the 5-year.
I agree with you. I think their reasoning for having a stay out makes sense, but as you mentioned, this is all new, so I'm not sure whether 5 years is.
It seems like a long, personal opinion is, it seems like a long time as a consumer. But as far as policy with the commission, I don't have insight onto whether that would be a long time or not.
And you don't know whether if, you don't know whether that, 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 if, you don't know whether other states that have a time of use tariff like this with a best bill provision, whether they have a stay out
I
for a
do
similar
not, I do
duration?
not have information on that.
I think that's all I have. I appreciate it.
Mr. Burnett, you may
I was so
stand
well
down.
prepared with so much information.
Well, you did great when you knew the address of the office, okay?
I've been working on that.
Ms. Kelleher.
Thank you, Mr. Chairman. General Staff calls Christopher Spadoni. Would you please state your name, your position, and your business address for the record, please?
So my name is Christopher Spadoni. I'm a rate case analyst 2 in the cost allocation and rate design section for the Arkansas Public Service Commission. My business address is 1000 Center Street, Little Rock, Arkansas 72201.
Are you the same Christopher Spadoni that filed direct testimony and direct exhibits on August 22nd, 2025, sir rebuttal testimony and sir rebuttal exhibits on October 17th, 2025, and amended sir rebuttal testimony and amended sir rebuttal exhibits on November 7th, 2025?
That all sounds correct.
Do you have any additions or revisions to your testimony?
I do not.
We tender the witness.
Thank you. Mr. Tate? Any questions for Mr. Spadoni?
Thank you, Chairman. Mr. Spadoni, is this your first time testifying in front of us?
It is, Commissioner.
Welcome.
Thank you. I'm very excited to be here.
We can tell.
I don't know the easiest way to go about this, so maybe I'll just start broadly. Can you walk us through the revenue distribution methodology that is being done here for the for cost allocation? Is the revenue being distributed equally? Is that?
So I was not included in the settlement negotiations, so the equal spread, if that is what you're asking about, I'm not well equipped to talk about. As far as attachment 2 to the settlement agreement goes, that was performed based off of staff's cost service study adjusted according to the settlement negotiations, and that's a cost-based revenue distribution.
You said you were not part of the settlement discussions?
I was not included in those negotiations, no.
Okay. I will hold my question then. Thank you, Chairman.
No questions, thank you.
Thank you, Mr. Spadoni. You may stand down.
All right, well, I promise to spend money in the state of Arkansas.
That's what I wanted to hear. Thank you.
Chairman, do you think we could take a 5-minute break?
Want to take a 5?
Can we take a 5-minute
Sure,
break?
let's,
Or 10 minutes
we're
if you
doing, we're
prefer.
doing great. Let's come back at 3:15. Let's take 15 minutes, okay? We'll stand in recess. You don't have, you don't have it bumped up to your back. Good enough. I know we all appreciate you working with us so that we can get this done today, rather than come back Friday. But I sincerely appreciate the attorneys and the witnesses for doing that. Okay? So Ms. Kelleher, call your next witness.
Staff calls Michael Marchand. Please state your name, your position, and your business address for the record.
Michael Marchand, kidding, 1000 Center Street, Little Rock, Arkansas, 72207.
And what is your title?
My title,
He doesn't know his title, but he knows where
well,
he
I'm the
works.
executive director. I think in this one I was the interim director of financial analysis.
Thank you. Are you the same Michael Marchand that filed direct testimony and direct exhibits on August 22nd, 2025, sir rebuttal testimony and sir rebuttal exhibits on October 17th, 2025, settlement testimony and settlement exhibits filed on November 10th, 2025, errata settlement testimony filed on November 13th, 2025?
Yes,
Do you have any changes or revisions to that testimony?
I do not.
Tender the witness.
Thank you. Ms. Anderson?
No questions. Thank
Mr. Tate? This is your chance. You've got him under oath.
I've been waiting a long time.
Nowhere to run, nowhere to hide.
Mr. Marchand, I'm looking at Joint Exhibit A. Let's see, page 9 and 10 of the settlement agreement. Specifically paragraph E. If the commission approves this settlement, is the commission making a determination on the prudence of Perky? On the retirement of Perky?
I'm sorry, page 9.
Yeah, I'm looking at Joint Exhibit A. So it's under Roman numeral 3 for rights of the settling parties.
Okay.
Talks about, specifically in reference to this, that the settlement is not commission precedent.
Oh.
And so as far as us approving this settlement, part of that settlement is a determination by the settling parties that the retirement of Perky is prudent. If we approve the settlement, is that a commission finding that the retirement of Perky was prudent?
I am not an attorney.
We couldn't
I'll
get out of here.
caveat that.
We couldn't get out of here without somebody saying
I
that.
should have said that right off the bat. I would, in my mind, it would be a finding of prudence because the settlement is basically allowing the cost recovery.
Do you believe that's a commission finding then, that the retirement is prudent?
Yes.
It would not be precedential though? At least
No.
under the terms of the settlement agreement?
No.
Would you agree that at least based on the various settlement agreements the parties have brought to the commission over the years, there is some inconsistency on whether a return is permitted or not? And if so, what that return should be?
Well, I might disagree with inconsistency, but there's been different support for the return that's been allowed on different assets.
So when I talk about inconsistency, I mean whether a return has been allowed or not has been different depending on the resource retiring.
Yes, I would agree with that.
And if a return is permitted, what that return should be has also changed depending on the resource.
Yes, I would agree.
And primarily that has occurred through the settlement of parties, correct?
Yes.
I anticipate we're going to see more retirements, not just from this company, but from other utilities in the future. Should we anticipate that how this commission treats those retirements and what should be expected is going to be done just through settlement, or what should the commission policy be going forward? I understand SWEPCO's position about there has to be some type of resource-specific determination made, but what should the default be? And then whether you're going to do that analysis, what to deviate from that? It's a bit convoluted, but again, I understand we've done things differently. Most of it has been through settlement. What should the commission policy be outside of this settlement for retirements of early retirements of facilities?
I understand, I think, what you're asking. It's a great question. I don't know. We have talked internally, just staff, when we talk about this kind of stuff, about it being possibly included in the IRP process. I mean, if they have to, plan for generation additions, possibly including some sort of planning for how those might retire or what that runway might look like. But I think that would be really helpful to have guidance on that type of thing. I don't know if you would want to have I don't know that there's a one size fits all for, because each resource is different. And I think the commission has acknowledged that in previous dockets. So does that answer your question?
Yeah, I think so. You don't think there should be a one size fits all or kind of a default? Unfortunately, if we do that, there's no expectation coming in, right? The parties don't know what to expect.
Right.
Do you agree with SWEPCO that it should be expected that there will be a return on a prudent early retirement, and that absent the prudence of the retirement being in question, there'll be some form of a return on that?
Again, I think it would be resource specific, but I think if it's if the retirement is, if it's prudent to retire the resource early, that they shouldn't be penalized for that.
And you consider it a penalty if the retirement is deemed prudent for them not to get a return on that investment?
Well, I mean, if you're planning and you build a resource to last for 40 years, when you're evaluating the different resources, before you even build it, you're looking at what the return will be on that resource for the 40 years. And so once you commit to it, it's kind of, you've already planned for that. And you're already, there's an expectation that the return will be associated with that asset lasting the entire time. So, if it's prudent to retire it early, I don't know that it would be, I don't know if it would be considered punitive or not to not allow a return on that.
Does your position at all change if you accelerate the depreciation?
No, and I think that's
your position doesn't change?
Oh, I'm sorry. Can you repeat the question?
So whether they should get a return on the investment or not, you think whether you accelerate the depreciation doesn't affect that?
No, and that, that is, as an example, something that could be addressed in the IRP. If they know, if it's identified that they have a resource that might need to retire early, that's something that could be explored and addressed whenever, depreciation rates are addressed.
You were in the room for the discussions about riders, specifically Act 373 and its effect, or whether it should have an effect on ROE.
Yes.
You took a position, at least early on, and I think you maintained it through settlement, that it does reduce risk and should be reflected in the ROE. Is that an accurate portrayal of your position?
Somewhat. Staff, when we looked at, when we did an assessment to determine a reasonable ROE, part of that is, or most of that is looking at the returns on equity that would be expected from an investment in a similar enterprise. So we looked to the proxy group. And so what we did is we looked at the jurisdictions that the proxy group companies serve from a generation standpoint. And based on that, we determined that Arkansas was different or unique in that they had this mechanism that had been approved by Act 373. So we determined that the appropriate place to recognize that would be as a reduction to the ROE, because the ROE is determined by the companies serving those other jurisdictions.
So the ROE that's agreed to in the settlement is below the midpoint of your proxy group, is that correct?
Yes, sir.
So is it your opinion that that ROE reflects that reduced risk?
Well, yes, to answer your question, I'll elaborate a little bit if that's okay.
Sure.
So my ROE recommendation was at the bottom of the range to recognize that. Other than that, at a risk of shooting myself in the foot, it was a little arbitrary. I didn't really have a basis for 9.5%, but I knew an adjustment needed to be made, and so the bottom of the range was just as good as any point recommendation. So the 9.65% being below the midpoint acknowledges that, and also was part of the settlement.
I think that's all I have, but just to be clear, I've got a question about cost allocation. Ms. Butler is the settlement witness. Is she the appropriate person to ask about that?
You can ask me about it. I don't know if I'll try to have the answer. Cost allocation is not my strong point, but I'm happy to try to answer it.
Give me just a second. So the compliance tariffs for the new base rates that reflect the agreement are using staff's billing determinants.
Yes.
And the revenue distribution methodology as recommended by the company.
Yes.
Does that revenue distribution methodology, which I believe is reflected as an equal distribution?
Yes, it's based on the average, I believe.
Does it adequately mitigate any large increases to any specific class?
Yes.
You believe so?
I believe so. Yes.
That's all I have, Chairman. Thank you.
Thank you.
Mr. Marjan, you may stand down.
Thank you, Chairman.
Will you go spend money also?
I have 3 kids. I'll be spending a lot of money.
Good. Thank you for your service. Ms. Kelleher?
General Staff calls Regina Butler. Ready? Would you please state your name, your position, and your business address?
My name is Regina Butler. I am the Director of the Electric Utility Section for the General Staff of the Arkansas Public Service Commission. My business address is 1000 Center Street, Little Rock, Arkansas.
Are you the same Regina Butler that filed settlement testimony on November 10th of 2025?
Yes, I am.
Do you have any corrections or revisions to your testimony?
No.
All right. Tender the witness.
Thank you. Ms. Anderson? No
questions
questions?
right
Mr. Tate?
Ms. Butler, did you hear the question I asked Ms. Gage earlier that I believe she's going to try and address when she comes back up about the, let me see if I can get the terminology right. There's a portion of Perky that I think is discussed in the agreement about being deferred. Do you recall what I'm discussing or I'm talking about?
Yes, I believe so.
From your perspective, can you explain what that is?
Yes, I think so. Are you able to point me to the paragraph in the
So I think
settlement?
it's paragraph 4 of the joint exhibit. It says the 3% return is effective October 15th, 2024, when the formula rates were last changed, with a deferred return to be addressed in the next base rate case.
Okay, yes, thank you. Well, that lines up with the settlement agreement that was approved in SWEPCO's last formula rate review filing. Specifically, the provision for, no decision was made on the treatment of the retirement of Perky in that particular case. And the parties agreed that the SWEPCO would set up a regulatory asset and the issue would be addressed in the next base rate case. So this is the next base rate case.
So there's not some portion that if we approve this will be deferred and addressed at a future or later time? That's not your understanding anyways?
That's correct.
Okay.
And I hope Ms. Gage will agree.
I think just one last question. Did we make a prudence determination for Dole Hills in the last rate case?
I don't think you did.
So despite a lack of a prudence decision, is there a need for a decision on that? Because I noticed that none of the parties address it in this rate case.
A decision on Dole Hills or Perky?
On Dole Hills.
I don't think there is a need. If I'm remembering correctly, it was a 5-year amortization in 2107 to you. So
With no return on, correct?
correct,
And no determination of whether retirement was actually prudent, right?
correct.
Okay. And you don't see a need for us to make a determination on that since we've already determined rate recovery?
That's right.
Okay. That's all I have, Chairman.
Ms. Anderson?
No questions, thank you.
You may stand down. Thank you for your service.
Thank you.
Ms. Bennett, we would like to call your captive, Miss Tacker. Oh, sorry. Hey, these things run
That
together.
was Monday's
okay?
hearing.
That was my friend KK, I'm sure.
Yes, yes.
Yes, sir. Is now an appropriate time to recall Ms. Gage?
Yes, it is.
SWEPCO calls Melissa Gage to the stand.
It would be hard for Miss Bennett to call Miss Cage.
Well, I texted her earlier today. I could, try to get her on the phone.
Okay, that's all right. Thank you.
We tender Ms. Gage for additional questions from the commission, Your Honor.
Thank you. Did you want to follow up?
Do you guys have any questions or you just want me to follow up? Okay. Do you have a response to the question we discussed earlier and similar to what I just asked Ms. Butler as far as the deferred amount?
Yes, sir. So a slight clarification to what Ms. Butler just testified to. That 3% is when the FRR rates were last changed, that reg asset, the 3% return on it, there's going to be an amount from the FRR period until when we implement rates in this period.
Yeah, so from 2024 to when the compliance tariffs are filed and in effect,
Correct.
that amount you'll carry till the next rate case.
Correct. And we'll seek recovery of it in the next rate case. So it's that small piece. That's what this sentence is referring to. And I apologize if I created confusion. I just didn't want to be wrong earlier. But
Well, I just want to make sure we're all clear on what that is, and I'm not positive at this point that everybody is clear on what that is. I think the last question is just whether you agree with the statement made earlier that if we approve this settlement, which as proposed provides a return on the retirement of Perky, whether that is precedential or not for future retirement decisions.
I am a lawyer, but I'm not sitting here as a lawyer. So, but
Well, you also are the settlement
right.
witness,
So,
and
but
there's a provision that seems to address it in
right.
the
So,
settlement.
so notwithstanding, I mean, the terms of this settlement say that it's not precedential. So because of that, I would say I do not think it is precedential. However, I do think we are asking the commission to determine as part of the settlement agreement that the closure of Perky was prudent because that's term 29 in the settlement agreement. So I do think that determination is being made here. I would agree with you all that we can't later cite it as precedent by the commission.
I think that's all I have. I appreciate it.
No questions, thank you.
Yes, sir.
Or maybe more than one.
Uh-oh.
And I think you said
You-
all the
you-
Mountain
you-
Dew, so
How
hang
many
on.
Mountain Dews have you
Hang in
had,
there.
sir?
I think you're the only Texan in the room.
I was specifically instructed by Mr. Madison not to bring that up.
But I think that's correct. Is there another one here?
I might be alone. Is
Miss
there
Smith,
about-
are you
is
an
everyone gonna gang up
Oklahomian?
on me?
Are you ready to run?
Miss Smith, are you an Oklahomian? Oh, well, okay. I just need to help correct history of Texas. And since you're here, you get to be the one, okay? I guess you've heard of Stephen F. Austin.
Yes, sir.
And I think he's kind of a significant person in the state of Texas at one time.
I would agree.
You know that at one time he was a resident of Arkansas.
I did not know this.
You did not know that. Well, let's acquaint you with that. Stephen F. Austin was a resident of Arkansas prior to statehood of Arkansas, prior to 1836. Of course, Texas became a territory in 1836 and once again tried to take the glory away from Arkansas, okay? Well, we had an election in Arkansas to elect a territorial representative to Congress from Arkansas. And believe it or not, Stephen F. Austin ran, and he lost. And the moral of that story is, if you can't win in Arkansas, move to Texas.
Noted.
And that's all true, okay? That's true, correct history, okay?
They didn't teach us that in 7th grade Texas history, but we leave out the parts that we don't like, I think.
Well, so true of the state of Texas, okay? Yeah, I made one of your attorneys take off the star last week. He was wearing a star on his lapel. I said, I can't, that'll prejudice this whole case. You need to take that off, okay? So let's do this. Well, let's answer this phone.
Your Honor,
Yes,
may I offer one more item, please?
one more. Of course you can. Don't refute my fact, okay?
Yeah, yes, sir. If it would be helpful for the commission, we are happy, the company is happy to file under council letter the reports with regard to the number of customers in arrears as well as the dollar amounts. We could do that by Wednesday of next week if that would be useful for the commission.
And if you could find out or determine the square footage of those houses.
I will certainly endeavor
See
to
if you
do
can
that.
do that,
Yes,
okay?
yes. And Commissioner Anderson, just so you know, I do have an inquiry into the billing folks to see whether or not we could differentiate that information on a geographical basis, but I can't make any commitments as to that information at this time.
Okay, you mean just for this report that you could
Yes, ma'am.
potentially file rather quickly?
Yes.
Okay, okay. But in the future, if any future reports that we
I would need to investigate yes, can we provide the information? I am certain we can. The amount of time that it would take to query and compile, we would probably like the opportunity to discuss with you the best way to present the information that you need.
Okay, that will be fine. Thank you.
Yes, so we'll file that on Wednesday.
Okay.
Thank you.
I think Wednesday's fine. Does that work?
Yep.
That's fine. Thank you.
Thank you, Ms. Tacker. Well, I want to appreciate everyone for being here and the work we've done today. The commission looks forward to conducting 2 public comment hearings. The first is scheduled for December the 2nd at Northwest Arkansas Community College in Fayetteville, and the second is scheduled for December the 4th at the University of Arkansas Costat Community College in Ashdown. Ms. Gage, we appreciate your staying all day with us.
I will also commit to spending more money here in the great state of Arkansas tonight.
You then are excused. You
Thank
may
you, sir.
stand down. Are there any other matters that need to be brought before us? If not, this hearing is adjourned, but we will leave the record open for any post-hearing commission questions. And the other thing we have learned today,
And the report that.
and the report that you will be filing, and we all know that the Public Service Commission of Arkansas is located at 1000 Center Street, Little Rock, Arkansas, 72203, okay? So, y'all, we really appreciate you. We appreciate staff. We appreciate all of y'all staying with us. So be safe and enjoy the Thanksgiving holiday. Thank you.